right, back on the record in the Simpson matter. The defendant's again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Neufeld, Mr. Scheck, people represented by Ms. Clark and Mr. Darden. Jury is not present. Counsel, anything we need to take up before we invite the jurors to rejoin us?
Your Honor,
Mr.
I
Scheck.
think outstanding, we still had the question of whether or not the defense would be allowed to recall Gary Sims, and I should make an offer with respect to that.
Okay.
If Mr. Sims were called to testify to the witness stand, he would testify about a wet transfer that went from Surface 1 to Surface 2 to Surface 3 on the B sock. We've had extensive testimony about what we've called, I guess, the A sock, but this would be the B sock.
That was Professor McDonald's testimony, correct?
Well, Professor
Amongst others.
McDonald and Dr. Lee testified about the A sock.
Right.
And what we have now is Gary Sims making an observation that there was a wet transfer.
Out of curiosity, why did we wait till this late point to...
Well, that's, I think, what the prosecution's position is. I should add, incidentally, Your Honor, that the stain in question on the B sock is also one that typed with PCR markers as being consistent with Nicole Brown Simpson. The July 17th, we received a report from Dr. DeForest and Gary Sims, which noted this wet transfer, and we did not receive photomicrographs of this until some later point in time. I readily concede on July 17th we were aware that they had made these observations, but the photomicrographs of exactly what they saw and the pictures that they took were not made available for quite some time. I'm sure, as the court recalls, they were proffered to the court, as I understand it, and you would have the best information, at a 1054.7 by Mr. Hodgman. And then, as I recall the court noting, you had them from quite some period of time because you couldn't figure out what they were because they weren't labeled. And I think that the photomicrographs...
They weren't labeled and they were just notes, so I had to have them interpreted for me.
Right. And the other thing I will note, however, just to make sure that the record is completely clear, there was some notation on Mr. Sims's original notes about seeing stains, but the significance of the wet transfer and the specific finding of the wet transfer, and most of all the photomicrographs, were not available till later. I should note that one of the great ironies, in my judgment in this case, is that we wound up giving the prosecution all of Dr. Blake's pictures, all of Dr. Lee's pictures, all the pictures, and to this day, in dribs and drabs, we get Mr. Sims's pictures. And only a few of them, one on redirect examination at the last moment, and then these photomicrographs, which we would submit or exculpatory evidence
So the
at
basis
the 11th
of your
hour.
argument, excuse me, Mr. Scheck, forgive me for interrupting you.
I'm finished, actually.
Let me just ask you a question. So the genesis of your inquiry as to this wet transfer was Dr. DeForest's notes?
That was, yes, the joint examination of Sims and DeForest on July 17th, and the ultimate basis for us doing it was the receipt of the photomicrographs 10 days ago.
People?
Well, Your Honor, I don't know how Mr. Scheck can argue that. The notes turned over to us that were made by Mr. McDonald and Mr. Lee reflect that were made during the examination by Mr. McDonald and Mr. Lee in February of 1995 reflected they saw Sock B, found the stains they're talking about, made notes, and indicated explicitly the stain they want to go into now on Sock B. In February of 95, they knew about that. They elected not to go into that with their own expert on the witness stand, Mr. McDonald, and elected specifically to limit their inquiry to Sock A, even though they had their own examination, their own photographs, their own notes and conclusions concerning that sock well in hand for months. July 17th added nothing. Now, Gary Sims' notes reflect all of these stains that we're talking about on both socks, and they were made in November of '94 and turned over immediately thereafter. So the defense has had notice of this since November of '94. Their own experts' reexamination, which occurred on February 16th, 1995, revealed that they had similar observations. Their conclusions, of course, about the significance of those observations are vastly different than our experts. But July 17th, even if we assume that they knew nothing about it until July 17th, when Gary Sims, Greg Matheson, and Peter DeForest looked again at the same stains and again made the same observations that were made earlier in November by Gary Sims, even if we assume that that's what triggered the defense inquiry, it was still during their case. Bear in mind, Your Honor, when did the defense conditionally rest? Basically rest? What was that, a week ago? Week and a half ago? And they want to tell us that not until that they conducted their case for more than 2 months, and during that time, after having had 2 months, not only the reports of their experts since February, but our experts since November and then again in July, they're only thinking of it now. The defense has given you absolutely no reason to permit this. But I can promise the court this. This is very confusing stuff. And if they put on Gary Sims to give his conclusion, the people, in all fairness, will have to rebut. We have to rebut so the jury is not left with a misimpression about what the significance of these stains are. We will have to call Greg Matheson. We will have to call Peter DeForest.
What's the possible misapplication of this evidence that the jury might be inclined to take from this?
Well, the defense is obviously going to want to present this as evidence of planting again. And what they're going to do, what the pernicious aspect of this is that Gary Sims is not a blood spatter expert. He has certain observations. His opinion is that, of course, it was not planted. And the appearance of what he sees on that stain does not support that theory, and yet he will be substantially attacked by the defense if he attempts to render any opinion as to the logic of inferring planting from the appearance of the surface 3 of that sock. We will then have to call 2 others to explain their theories as to what could have occurred to cause the transfer. We have Peter DeForest, who is a blood spatter expert, and Greg Matheson, whose testimony is relevant because he saw the socks earliest in time and can testify to the nature of their handling and packaging and care that will give substantial reasons for the jury to understand why this is not evidence of planting at all, but a very simple and logical explanation can be given. So, we are going to talk about another few days of testimony. As the court knows, expert testimony takes a very long time to elicit, and counsel's been very thorough in examination and cross-examination, all for a piece of evidence that they had for months and elected not to use. This is willful delay, Your Honor. If the defense thought this was so almighty important, they had every opportunity to put it in during their case in chief and elected not to. And our experts' re-examination added nothing to their knowledge on July 17th. Their own experts made those notes in February. They knew.
Anything about your rebuttal case that would open the door here?
With respect to the socks, I haven't even had a chance to think about that. I'd have to go and confer. I'm sure that it would, because we're talking again about the whole planting theory, which goes back to the conspiracy theory. I'm so tired, Your Honor. I'm going to need a moment to consider the full ramifications. I'm talking, when I say I'm going to need to call those 2 witnesses,
This has been a rather mind-numbing experience.
Well put. I agree. In any case, Your Honor, I'm only talking about the limited direct rebuttal we'll need to present to this testimony, and that's just that. And I'm not even sure what this evidence adds to the defense case. They presented their theory through the stain on sock A. If they really thought sock B was that important, they certainly had the knowledge. They had the witnesses right on the witness stand, Dr. Lee and Mr. McDonald, right in their notes. It's not, the defense is not telling you they didn't know. This is gosh, we really want a better closer. I mean, we can go on for days like this, searching for a better closer, Your Honor, but it adds, I don't know what it adds, except a lot of time to a very tired jury and a lot of very technical testimony that will be needed to sift through the implications the defense seeks to draw. I would need a little time to ponder what additional testimony the people would need or be entitled to present as a result of the door opened by this.
Mr. Scheck?
Just two brief comments, Your Honor. I realize that it is a very tiring experience for all of us, but I hope this is not a preview about how facts are stated in closing argument. The fact of the matter is that there was an examination in February by Dr. Lee using a microscope from the LAPD that I believe the testimony was constantly out of focus and didn't go more than 2 times. So I think that she's just misstating what kinds of observations could be made. Yes, stains were seen on the both socks. They were observed, but not with the level of particularity that are required to make an evaluation of these wet transfers. I will agree that Gary Sims is not a blood spatter expert, and we're only bringing him in for observation of scientific fact, and I certainly don't expect to hear the prosecution argue and put in their closing argument that he was a blood spatter expert. Indeed, I think that's what makes this more significant, that when the prosecution's own blood spatter expert, Peter DeForest, saw it on July 17th, the full significance of the observations became apparent.
Well, Mr. Scheck, if the defense did in fact though have access to the sock, and if Dr. McDonald did have the opportunity to look at this, and if blood stains were noted on the interior of the sock, I mean, isn't that the whole point of this?
Well, it's in terms of their notes, it's not accurate to say that they made those particular observations when they looked at the sock in April with respect to the B sock. Secondly, I must say that I do reject the notion that if prosecution experts, upon further examination of the B sock after defense has raised issues about the A sock, come up with findings that are exculpatory, obviously exculpatory, they even presented to the court in chambers because they knew it was exculpatory. That's why we haven't seen Dr. DeForest in this case, I would submit, or it's certainly a fair implication. It doesn't seem to me that the argument that, well, the defense experts, had some kind of limited opportunity under certain circumstances to make observations of the sock, therefore they should be precluded from even putting on exculpatory evidence that the prosecution experts found.
But this all has to be done in a timely manner, though, is the concern.
Well,
Because at this point, we're talking about calling Mr. Sims down from Berkeley, and then I assume that this is going to require Dr. DeForest from New York.
well, not from our point of view. What we needed were the pictures. Proof.
All right, do you have the photomicrograph of this particular surface?
With us, we have them. Oh, and Mr. Sims has a set. We've discussed those with him on the phone.
Oh, I understand that. I'd like to see it.
Well, I thought you had seen it. You were the ones that you gave it back to us.
I'd like to refresh my recollection as to what's there to see how significant it is.
Well,
You don't have this, you're asking to call the witness, but you don't have the stuff available.
well, no, we asked him to bring the originals with him.
May I ask you to look at the notes of Dr. Lee concerning his examination of the socks in February and April? I think the court will then see clearly that Dr. Lee saw exactly what they want to now present in late September.
Does it say what transfer?
Well, it's circled. I'd like the court to see it. It's one page, it's a diagram. It's very clear that they knew what this was and the significance of it.
You got it?
I have you brought down right now.
Do you have Mr. Sims' photomicrographs available?
No, I don't. I didn't know there were any. This is the first I've heard about them.
All right. Well, let's do this, counsel. Let's proceed with Commander Bushy's testimony with the jury. After we conclude that, hopefully these materials will be available and I can determine that. All right? Yes, Mr. Neufeld, good morning.
Ms. Clark and I have entered into a stipulation regarding the syringe,
Bless you.
and we will introduce the syringe, and we can do that when you, at your pleasure.
All right, why don't we do Commander Bushy's testimony, and then we'll do the stipulation
Fine.
regarding the syringe, and then we'll see where we are with Dr. Lee's notes. All right?
May I ask one question with regard to Mr., so we can move this right along, which obviously we want to do. I just want to get some idea that if we can determine regarding Mr. Sims, maybe we can make some calls and make sure that if you can let us call him, he can be here,
This afternoon?
yes, as soon as possible. Do you want us to make some calls and check that out also? Because I think it would be wise to do that. We'd be in a position to rest at that point, conditionally rest.
I've got to find out before his turnaround, and then we're going to have to get Greg Madison in the town.
Well,
We're going into next week with this one.
Judge, the question is, while I'm still up here talking, the question is, you have to make that judgment. You have not been loath to exclude witnesses where you thought it was appropriate. And if they have nothing to say, they have to make an offer of proof. So it's not like they can threaten you with witnesses. That's your call. We made our presentation, right? So I'm just saying, as abundance of precaution, let's see if Sims could be here this afternoon if
All right,
possible.
let's do this. While we are going forward with Commander Bushy and with our syringe stipulation, perhaps we can have the attorneys not otherwise occupied check on the availability of these people so we have some guess.
All right, thank you. I think it's wise. Thank you.
All right. All right, Deputy Trier, let's have the jurors, please.
At some point, are we going to hear the defense rest?
Prosecution rest or something?
Well, you know, I mean, we've already put on a rebuttal case. We still haven't heard defense rest.
I know.
It would be nice.
I know.
Closure, you know.
Weird.
That'll happen this week.
We're going to rest this week, Your Honor. And the defense never rests, but we're going to rest this week because, as the court knows, the Supreme Court, we're waiting on the Supreme Court to tell us one final item, too. It'll help us decide whether we're going to rest. I mean, we're waiting imminently for the Supreme Court to speak on this issue, so that's another reason, counsel.
We'll wrap it up this week. And I'm sincerely hoping to at least, if we don't instruct Friday, then instructing on Tuesday and starting with arguments.
All rise.
Jury panel, good morning again, ladies and gentlemen. Ladies and gentlemen, one of the things that the trial court is empowered to do is to change the order of witnesses and change who gets to present evidence at what particular time. And if you recollect, I've required the prosecution to start their rebuttal case before the defense formally rested because there were some issues that were still left open. At this time, I'm going to allow the prosecution to call a witness in rebuttal to some of the defense case that we just heard, again, out of order, but in order to use your time and our time most efficiently. All right, Ms. Clark?
Thank you. People call Commander Bushy.
Do you solemnly swear that the testimony you may give in the trial not pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat and let us stand and state and spell your first and last names for the record.
Keith D. Bushy, B-U-S-H-E-Y.
Thank you.
Ms. Clark?
Thank you, Your Honor. Good morning, ladies and gentlemen. Sir, please tell us what your job is
Commander, Los Angeles Police Department.
and where are you assigned, sir?
I'm presently the commanding officer of the personnel group.
And can you tell us what your duties are and what your responsibilities are?
My present duties as the commanding officer of personnel group provide me in a position of oversight over several other department commands that deal with recruiting, hiring, promotions, transfers, equal opportunity, the Reserve Corps, medical issues, and employee assistance.
Were you so assigned on June the 12th, 1994?
No.
Can you tell us what your assignment was on June the 12th and 13th of 1994?
At that time, I was the Assistant Commanding Officer of Operations West Bureau.
And what were your duties at that time, sir?
As the Assistant Commanding Officer of Operations West Bureau, I was second in command to a Deputy Chief who was responsible for roughly 1/4 of the city of Los Angeles for the delivery of conventional police services to include patrol and investigative. And that portion of the city encompassed the geographic areas of Hollywood, Pacific, West Los Angeles, Wilshire, and also the West Traffic Division.
Is that all?
I specifically had functional responsibility over the detective function, and in the absence of the commanding officer who was ill on frequent occasion, I served as the commanding officer of that bureau.
Were you then acting as the commanding officer on the night of June the 12th and early morning hours of June the 13th, 1994?
I was acting as the assistant commanding officer that evening, yes.
When you say that you were supervisory, you had supervisory duties over the detective activities?
Not line supervision, but I had functional supervision over all investigative activities in that portion of the city.
And what does that mean in terms of what you supervised?
Oversight over the investigative function, the virtual investigation of all crimes that would be handled at the area level, to include the training, the deployment of detective personnel, ensuring that the commands had the resources they needed with which to carry out their functions, and overall oversight of the investigative function.
All right, so directing your attention then to the early morning hours of June the 13th, 1994, did you receive a phone call or speak with Detective Phillips?
Yes, I did.
And do you recall approximately when that was?
To the best of my recollection, and I'm sure that I'm pretty close, probably right around 2:30 in the morning.
And when I say Detective Phillips, are you aware of who I mean, Detective Ron Phillips?
Yes,
And you know him personally, do you, sir?
I do.
And who was in charge of that crime scene when you spoke to him at approximately 2:30 on the early morning hours of June 13th?
He was Detective Phillips.
And why did he call you?
I was called as part of the notification process within the police department. When certain things occur, certain notifications need to be made. In the instance of a particularly noteworthy crime, one that's likely to attract media attention, one of the things that takes place is the Bureau is notified, and I was the right person to notify.
So was that standard operating procedure then?
Yes.
Are they required also to keep you apprised of the developments of the case?
Significant developments, yes.
Now, sir, had you had any previous experience with a high-profile case?
Yes.
And what case was that?
Overruled.
The Belushi death.
John Belushi?
That's correct.
And was there some particular experience with respect to that, sir, concerning the habit or practice of notification to the next of kin?
Yes.
Can you tell us what that was?
Overruled. I take it that we're going to relate this directly to
Exactly.
briefly.
Very.
The Belushi situation was very troubling for me personally because the time frame from the time that his body was discovered until the media had that information was very, very short. And I felt very bad at the number of his relatives who most certainly learned about his death through the media rather than through the family notification process. And as a result of that and other experiences, one of the things that I've always felt very strongly about.
He's answered the question. Next question.
Now, after you spoke to Detective Phillips that night, sir, did you get another call from an officer at the scene?
Yes,
And who was that?
Captain Connie Dial.
And who is she?
She, at that time, was the commanding officer of West Los Angeles Patrol Division, and she was the ranking officer from West LA area who responded to that scene.
Now, when you spoke to Detective Phillips the first time, I think you indicated approximately 2:30 a.m. And by the way, that's an approximation, sir?
That's correct.
When you spoke to Detective Ron Phillips at that time, did you give him some command or order?
Yes.
And what was that?
Well, I gave him a suggestion, and I gave him an order. There were two pieces of information that I conveyed to Detective Phillips.
What was the suggestion, sir?
The suggestion was that the case had all the appearance of it looked like a big case, a lot of media attention, no suspect, and it had the potential to overwhelm the resources of.
Overruled. It's not
Had the
hearsay. He's telling us why he did this,
Right.
and what the suggestion was.
Had the potential to overwhelm the resources available at within an area homicide unit. And I told Detective Phillips to be sure to let me know if he needed resources beyond that which he had available to him at that time.
Okay. That was the suggestion.
That's correct.
And then you gave an order.
That's correct.
And what was the order?
I told him to find O.J. Simpson just as soon as humanly possible and notify O.J. Simpson of his ex-wife's death.
And why was that an order?
Certainly, there's always a notification, but the sooner we can make the notification to a principal, in this instance, Mr. Simpson, it stands to reason that that family notification will take place, and I wanted to do everything humanly possible to minimize the number of her relatives, nieces, nephews, uncles, aunts that would hear it over the media the next morning. I wanted her relatives to learn of her death through the family and not through the media. And the sooner we could make that notification, the more likely that would occur.
And so why was it that you ordered them to contact Mr. Simpson as opposed to her family?
Well, the ex-husband, but probably the big thing is that we had his children there, and I was thinking a dual custody type situation, and it seemed to me to seem to reason that it would be less difficult to contact him. Not only that, but he's a prominent personality and somebody that seemed like somebody we could get a hold of right away. But once again, the children there caused that to seem like a very good and necessary thing to do.
And first thing to do?
Absolutely, very first thing.
Now, when you said start the family notification process by notifying Mr. Simpson, what do you mean by that?
Well, I think it stands to reason, and certainly it does in my 30 years of police experience and 50 years as being a human being. I recognize that within a family, very, very good news and very, very bad news travels rapidly. And the sooner we can notify him, the sooner the rest of the family is likely to be aware of what occurred.
You mean you would expect him to call them?
Certainly.
Now, after you had that conversation and gave that suggestion and that order to Detective Phillips, you indicate that you got another call from Captain Connie Dial.
That's correct.
And approximately what time was that?
To the best of my recollection, probably an hour, perhaps an hour and a half later.
Was there some event occurring at the particular time that you got the call from her with respect to which division would be handling this case?
Yes.
And what was that, sir?
The decision had been made that indeed the resources of West LA Homicide may have been overwhelmed by the case, or may be overwhelmed by the case, and a request was made and approved that Robbery Homicide take over the investigation. And that's when Detectives Lang and Van Adder responded to the scene and did formally take over the investigation.
Now, when you received the call from Captain Dial, did she inform you as to whether anyone from Robbery Homicide was present?
I believe so. I believe that at that time both Van Adder and Lang were present.
And at the time that she was speaking to you, sir, did she describe what she was seeing at the crime scene?
Overruled. Yes or no?
Yes, she did.
Excuse me? In the hierarchy of the police department, sir, how does Detective Phillips rank with respect to, how did he rank with respect to his position and yours as of June the 13th, 1994?
Detective Phillips was and is a lead homicide investigator in West Los Angeles Detective Division. He holds the position of Detective 3. He works for Lieutenant Frank Spangler, who is the commanding officer of West Los Angeles Detectives. Lieutenant Spangler works for Captain Robert Kurth, who's the commanding officer of West Los Angeles area. Off to the side, but as a partner in leadership to Commander Kurth, is Captain Connie Dial, who commands the patrol division, but who shares call-out responsibilities with Captain Kurth. Captain Kurth, in turn, reports to Operations West Bureau, and at that time would have reported to myself or to Deputy Chief Frankel, whoever was available at the time.
I stopped counting. So that's what, like 4 levels between you?
At least 3.
Okay. Could Detective Phillips refuse to follow any order given by you, sir?
No.
Now, when you spoke to Captain Dial later on, could you get some sense from your conversation with her as to where she was as she spoke to you?
Absolutely.
And what was that?
She was standing at the crime scene, and I know that because she was describing the scene to me.
Now, at that time, you knew that Detective Van Adder and Detective Lang were there because robbery homicide had taken over.
Yes.
And did you inquire of her as to whether or not you had a suspect yet?
Yes, I did.
And what did you learn, sir?
Sustained.
She responded to you, did she not?
Yes.
She tell you O.J. Simpson was a suspect?
Sustained.
Okay. After you inquired of her as to whether or not there was a suspect, sir, based on what she told you, did you order anyone to be arrested?
Overruled. Overruled.
No.
And what was your state of mind after your conversation with her?
Sustained.
Goes to explain subsequent conduct, Your Honor?
Sustained.
I'm sorry? All right. In the conversation that you had with Captain Dial, did you give another order?
I asked some questions, and I reiterated my previous order that Mr. Simpson be notified as soon as possible.
And that was during the course of the conversation when you inquired as to whether or not there was a suspect?
That is correct.
And having heard her response, it was your reiteration of the order given previously to...
Sustained. Sustained. We've already gone through this.
After you got her response, sir, did you reiterate the order to notify Mr. Simpson?
Sustained. We've already asked this question, counsel.
All right, now you had previously ordered Detective Phillips to make sure he made personal notification, is that right?
That's correct.
And did you issue an order with respect to robbery homicide?
Yes.
And what was that order?
I explained to Captain Dial that even though robbery homicide had taken over the investigation, and even though robbery homicide was not in the chain of command of West Bureau, as a staff officer of the Los Angeles Police Department, I am reiterating my order, and I wanted robbery homicide to find Mr. Simpson as soon as possible and ensure that the notification took place. And I reiterated my rationale as to why I insisted that occur.
Was that a suggestion, sir?
That was not a suggestion. It was not a hint. It was an order.
And was it an order that you made very clear and you were very adamant about?
Unequivocally clear.
Now, you're aware that 4 detectives went to make notification to Mr. Simpson?
Yes,
And do you approve of that?
certainly.
Is that unusual?
No, not at all.
And why is that?
Well, I think each case is a little bit different. And in this case, we had some situations that had the potential of being very time-consuming. We had robbery homicide, I don't believe, was familiar with that area. We have a couple of detectives who are familiar with that geographic area. We don't know what type of, how many people are going to be where Mr. Simpson is. We don't know what degree of grief and we're going to have to deal with. It may be, and frequently is, that we have to leave somebody with a grieving relative until a clergyman or someone else shows up. We have a couple children involved, and those can become very complex issues. There's a likelihood that we might interview witnesses, and so it's not at all unusual that we'd have 4 detectives respond to a situation of that nature.
Now, was this in some sense preferential treatment, sir?
Yes, I think so.
And why is that?
Well, the Los Angeles Police Department always wants to do the very best job we can. There's no doubt about that. And there are some instances.
Overruled.
Okay. There's some instances where realistically you know that there's going to be particular scrutiny focused on a particular investigation, and this had all the earmarks of something that would have a lot of media attention, and it caused us to even be more determined to do the best job we possibly could.
And did that knowledge play any part in your specific and strong order to make personal notification to Mr. Simpson?
It is.
What, if any part, did that concern play in your order to have Mr. Simpson personally notified?
There was no doubt in my mind that as soon as the media became aware of this tragedy, it would be all over, virtually every TV station and every radio station. And I saw us in a race against time to make sure that that family was notified.
First.
First, that's correct.
Thank you, sir.
Thank you.
Mr. Cochran?
Morning, Commander Bushy.
Good morning, how are you?
Doing fine. How are you?
Good, thank you.
Morning, ladies and gentlemen. How are you? Now, Commander Bushy, you have described for us that you were the commanding officer in West Los Angeles back on June 12th of 1994. You were number 2 to Deputy Chief. Was it Ron Frankel at that point?
That's correct.
He was your boss at that point.
That's
Is that
correct.
correct? And you just described for us that you had some line responsibility for the detective division. Is that correct?
Functional.
Functional responsibility. And one of the detectives who worked in your functional responsibility was Mark Furman. Isn't that correct?
That's correct.
How long?
Sustained.
Well, he brought out that he had
Sustained.
functional responsibility.
Sustained.
Now, you, with regard to this this situation, you had been to New Orleans. You just returned home from New Orleans, Louisiana. Isn't that correct?
That's correct.
And what time did you get home on that date?
Probably around midnight.
And you received a call about 2:30 in the morning. Is that correct?
Correct.
And that call was from Ron Phillips. Is that correct?
I believe the call was initiated by the watch commander on the scene, and then he handed the phone to Detective Phillips. That's my recollection.
All right. At any rate, you had some contact with Ron Phillips by 2:30. Is that correct?
That's correct.
At that time, was Ron Phillips still the lead detective on the case?
Yes.
And did Ron Phillips at that time tell you that the names of the victims?
Yes, we knew the name of one of the victims, Miss Simpson, but we were not aware of the identity of the male.
So that at 2:30 a.m. he told you that the female victim was Nicole Brown Simpson?
Yes.
All right, and you recall that specifically?
Yes.
All right. And then armed with that information, you then directed him, suggested to him that he notify Mr. Simpson as soon as possible, right?
I did not suggest, I directed him.
You directed him.
That's correct.
All right. Now, you knew under LAPD policy that Mr. Simpson was the ex-husband or the divorced spouse of this particular lady. Isn't that correct?
That's not correct.
You didn't know that?
Under LAPD policy,
I'm
I
asking
knew.
you, did you know that Mr. Simpson was the ex-husband?
I believe that I did.
All right. And under LAPD policy, and in notifying the next of kin, Mr. Simpson would not be the next of kin, would he?
I don't know that,
Well, have you read your policy lately, sir?
well, no, I haven't read it lately, but that would certainly be the most logical person to contact for those children there.
But let's get back to my question. And my question, under the LAPD policy regarding next of kin, the ex-husband would not be the next of kin. Wouldn't her family, wouldn't her mother and her father be the next of kin, sir? Isn't that correct?
They would be the next of kin, sure.
Right. Did you take any efforts to have them notified, sir?
I did not know.
All right. And so you, as the commander, you understand the LAPD policy, and you're sworn to uphold that policy, aren't you?
Yes.
All right. The LAPD tries to uphold their own policies, don't they?
Say again?
You try to uphold your own policies,
Certainly.
don't you? All right. Now, so no effort was made to call the Brown family, but to notify the ex-husband, Mr. Simpson. Is that correct? At 2:30, per your order?
We had no knowledge of how to contact the Brown family. We did feel that we could contact Mr. Simpson. We were driven by practicality in that instance.
I see. Did the Los Angeles Police Department has unlimited resources to locate people throughout the world. Isn't that correct, sir?
I wouldn't say unlimited.
Well, you have resources, but you can locate people throughout the world. Isn't that correct, sir?
Well, we do.
All right. Now, at any rate, at 2:30 in the morning, you indicated per order to Ron Phillips to notify O.J. Simpson regarding the death of his ex-wife as soon as possible. Is that correct?
That's correct.
Do you know what time that notification was made?
It was made at some time after that. I don't recall the exact time, but it was made at some time after that.
Would you be surprised the notification was made after 5 o'clock in the morning, perhaps 2.5 hours later, more than that?
I would have preferred the notification before then.
That's not my question. My question, are you aware
Yes.
that your order, which he was duty-bound to follow, was complied with some 2.5 hours or more later? You
Yes.
aware of that?
Yes.
All right. Now, and in that connection, are you aware that all 4 detectives in your division, which you're in charge, left the crime scene 2.5 hours later after your order to go to notify the husband, who is not the next of kin, and left the crime scene without a detective there? Do you understand that?
Yes.
All right?
Objection, objection, that misstates the testimony.
Well, without one of the working detectives there.
Oh,
Now, when you were talking to Detective Phillips about resources and various things, did you ask him whether or not he'd call the coroner's office so the bodies would be treated with some dignity and removed from that scene? Did you ask him that?
Objection, that's beyond the scope and irrelevant.
No, I think-
sustain,
Gonna
sustain,
to go to the coroner?
sustain,
Resources?
sustain.
Did you ask him about whether or not any criminalists had been called to come to the scene?
No.
It would be within your authority to help and assist through Special Investigation Division to get criminalists out to that scene. Couldn't you have done that?
All beyond the scope.
Nope.
Sustain.
Now, at some point, you became aware that Ron Phillips and Mark Furman were taken off this case. Isn't that correct? That it was taken over by robbery homicide downtown?
Taken over by robbery homicide would be a better term.
Okay, taken over by then.
That's correct.
And so they were basically off the case at that point. It was handled by Van Adder and Lang, right?
Well, they would continue to assist subordinate to Van Adder and Lang.
All right.
That would be our common practice.
They would then be in charge, right?
Van Adder and Lang would, that's correct.
Do you know what time that took place?
I'd be speculating.
All right, well, please don't speculate. But at 2:30, was it your understanding at 2:30 that Phillips and Furman were still in charge of the case at that point?
Yes.
And you gave Phillips a direct order at that point, is that correct?
Direct order.
Now, you mentioned the fact that your interest in this whole area was steeped and piqued by your experience in the John Belushi case, is that correct?
Not exclusively.
Well, that was an example you gave for us.
That was
here,
an
is that
example I
correct?
provided.
And in the Belushi case, there wasn't an immediate response to the scene by the coroner, or was there?
Objection, irrelevant.
Sustained.
Well,
Sustained.
are you aware that Dr. Michael Batten testified as a
Sustained. Sustained. It's not relevant.
Belushi
counsel.
case?
Over at the sidebar with the court board, please. Thank you, counsel.
Back to the Belushi case for a moment. In that case, was there a problem with the Los Angeles Police Department notifying Mr. Belushi's next of kin?
I'm not aware that there was a problem.
Well, you used that as an example, or Ms. Clark did. It's something that the family found out through the media before they were notified. Is that what happened?
That's the time frame from the time that Mr. Belushi was discovered until the media had a hold of it was so short that it would have been virtually impossible for his extended family to become aware of it.
Right. And it was, I'm sure it was a lesser time than 2.5 hours, wasn't it?
as I recall, yes.
Right. And in this case, you're aware that there was at least 2.5 or more hours before Mr. Simpson was even contacted. You know that, right?
That's correct.
That was state testimony,
2.5 or more. Now, in that connection, you described for this jury that it's not unusual for all 4 detectives who are investigating a murder scene where the bodies are still there to get in cars and leave and go to give a notification. Is that what you said to this jury?
Yes.
And in that connection, what do 4 detectives do to go notify one person? I mean, does it take 4 people to notify one person?
Well, I think I've answered that question, but I'll answer it one more time.
Answer it for me.
Okay.
If you'd be so kind.
Well, first of all, we've got a very high-profile case. We've got a couple of victims involved. We've got somebody that needs to be notified. We don't know how many other people may be there. There may be a need for somebody to stay with the victim until the clergy gets there. We may have additional witness statements. We have a couple children that need to be attended to. And those 4 had been at that scene conducting quite a comprehensive examination for a couple hours before having made that notification. So
Sir.
the scene was pretty well taken care of.
Sir, when you say the scene was taken care of, are you aware the coroner's office hadn't even been called? Are you aware of that? Oh, okay. Oh. Are you aware the coroner's office hadn't even been called?
I have no personal knowledge of that.
All right. If I were to tell you the coroner's office wasn't called until almost 10 hours after, would that refresh your recollection?
That is.
All right, I'll move on. Were you aware the criminals hadn't been called?
Objection irrelevant beyond scope.
Would you, now, you've had some experience coming up through the ranks of the LAPD, and you're aware that the first couple of hours after a homicide are the most important hours in the investigation, isn't that correct?
They certainly can be.
All right, and then you have 4 detectives leaving the scene and going over to give this notification, is that right? Is that what you're telling us?
After having been at the scene for a couple hours, they left.
Yes, but are you aware what they did at the scene for a couple of hours?
Well, I'm sure they were very busy.
Well, were you there, sir?
No, I wasn't.
So that we're clear, all of these conversations we're talking about took place from the confines of your home. Weren't you in the house?
That's correct.
All right, you didn't come out to the scene, did you?
No,
You talked on the phone.
that's correct.
And so all of your awareness is from having returned from New Orleans and having these phone conversations with these various officers. Is that right?
No, that's not right.
You had phone conversations?
No, but some of my awareness comes from my knowledge of the practices and the personnel involved.
Well, no, I'm talking about your awareness of what was going on at the scene came from phone conversations.
That's
Is that
correct.
Right? All right. Now, the order that you gave, was your order to Phillips to personally go and make the notification himself?
I believe it probably was. I don't recall the exact wording. It was probably, I want to ensure that Mr. Simpson is notified as soon as possible.
Well, now, as an experienced number 2 in command in the entire division, what you would want is the important thing was the notification, isn't that correct? So that there wouldn't be this problem that you felt in the Belushi case, isn't that correct?
That's correct.
And so it didn't matter whether it was Phillips or someone that he could have designated someone, isn't that correct, sir?
Well, it's usually the detectives on the case.
Now, I'm asking you specifically with regard to your order in this case. It could have been someone else, any other officers, isn't that correct?
Objection, that's speculation and irrelevant.
Let me ask. Oh, isn't that
It would have
correct?
been out of character for our policies, but it could have been someone else, yes.
All right. You didn't make the order specific to Phillips then. So it could have been, he could have designated another officer to go and do it, isn't that correct?
Objection, that misstates testimony.
Oh, isn't that correct?
I would have been disappointed, but he could have.
All right, you're disappointed he didn't do it right away, isn't that correct also?
Well, there's a lot of other things that need to be done. That was not the only thing that needed to be done. And remember, I said as soon as possible. Impossible means when it's practicable within the scope of the investigation.
Right.
There were other things taking place.
All right, but since you weren't there, do you think the 2.5 hours was as soon as possible?
Well, given the magnitude of that crime scene, it's not surprising that they had to spend some time there.
All right, and given the magnitude of the crime scene, do you think they should have called the coroner's office right away?
Objection.
Sustained.
All right, now, I want you to name for this jury one other case where 4 lead detectives at a crime scene left to go give notification to a person who was not the next of kin.
Well, I can't.
Objection, that's argumentative.
Oh.
You know, in most cases, I'm not.
Could you answer my question, please, sir, if possible?
I cannot give you a specific case.
Okay.
However, there's not been another case like this one either.
I just asked you to give me an example, sir.
Okay.
And the answer is you can't, right? Is that what you're saying to us?
If I were to give it some thought, or there had been some additional dialogue, I might be able to.
But you keep thinking about it. For right now, you can't you?
That's
sir?
correct.
All right, sir. Thank you very kindly. May I have just a second, Your Honor? apologize. Now, with regard to the sequence of events, and you've shared with us that at 2:30, thereabouts, you had this conversation with Phillips, and it was your belief that Phillips and Furman were still on the case at that point. Are you aware that...
Objection. Counsel testifying. Was there a
Now,
question?
that was a prefatory to a question. Your Honor.
Proceed.
Thank you. Are you aware that Detectives Lang and Van Adder did not arrive at the scene until perhaps 4:30 in the morning? Are you aware of that?
I don't know the specific time they arrived.
All right. Now, are you aware that during the time after your direct order to Phillips or his designee from 2:30, that no one went over to notify Mr. Simpson or anyone else between 2:30 and the arrival of Lang and Van Adder, let's say between 4 and 4:30? Are you aware of that?
That's my understanding, yes.
And are you aware of what time officially in the LAPD logs that robbery homicide took over this case? Do you recall that?
No.
You've not heard the testimony about that in this case tonight, have you?
I have not heard the testimony, nor have I reviewed the documents.
Did you ever talk to Detective Furman that night?
No.
Were
No,
you
I
aware-
did not.
You did not?
I did not.
Were you aware of whether or not he had any prior knowledge of the Simpson location?
Sustained.
When you had this conversation with Captain Connie Dial, who was the captain in patrol that particular night, about what time was that?
To the best of my recollection, it was probably an hour and a half or so after my conversation with Detective Phillips. I would
So
have put
you-
it between 4 or 4:30, probably somewhere in that vicinity.
What time?
4:30,
Well, I thought you talked with, did you talk to Phillips at 2:30?
about 2:30, yeah.
All right. And isn't it true, according to your report, that you talked with Commander Connie Dial about 1 hour later?
Hour and a half, hour and 45 minutes, somewhere. I couldn't be specific.
Well, let me show you a report, see if it's fresh your recollection. May I approach you?
You may.
I'll place the report before you, sir. It's an investigator's report. I'll ask you to, I'll direct your attention to a time frame as to when you talk to Commander Connie Dow. Read that sentence there and see whether or not that refreshes your recollection, sir.
Yes, I read it.
Have you read that?
Yes.
And this is purports to be a statement taken from you, I guess, on September 11th, 1994, by Dana Thompson, a senior investigator in the district attorney's office?
94, 95.
95.
That's probably a pretty accurate reflection of what I said.
Right, last week. And at that time, you told him, did you not, that approximately 1 hour later, after your conversation with Phillips, that you spoke with Captain Connie Dow,
That's correct.
right? So if you talked to Phillips at 2:30, you talked to Connie Dow at 3:30, right?
No.
You talked to Phillips at 2:30?
No, because I'm aware that at the time I spoke to Captain Dial, Van Adder and Lang were at the scene, so it would have to have been a little bit more than an hour.
Well, let me see. You talked to Phillips at 2:30, right?
That's correct.
And when you talked to Dana Thompson just last week, September 11th, you tried to be as accurate as you could. Is that correct?
Sure.
And you told him approximately 1 hour after talking to Phillips that you talked with Connie Dow. Isn't that right?
That's what I told him, yes.
All right, and you were wrong in that, right?
I think I was wrong.
All right, now you recall that it was later, and that robbery, homicide, and his detectives were already there.
Well, in preparation for this testimony, I've organized my thoughts and tried to reconcile some of the different time sequences, so I think the hour was probably on the lean side. Probably more like an hour and a half, maybe a little bit longer than that.
In preparing for your testimony, what have you read in connection with this case?
I've read nothing.
Well, how'd you prepare then?
Well, I've become aware that at the time I spoke to Captain Dial, Van Adder and Lang were at the scene, and I think I've learned from you just now that at the time their logs reflected they arrived at the scene. So if you were accurate, that means that I was probably inaccurate with an hour is probably a little bit longer than that.
So you think it was by 4:30 at that point?
Whatever time I talked to Captain Dial, Van Adder and Lang were at the scene, so it would have been more than an hour after my conversation with Detective Phillips.
So you knew then, 2 hours after you gave a direct order to Phillips, that he had not complied with your order or sent anyone else over there. Isn't that correct?
Yes.
Did you, as a commanding officer, did you get after him?
No.
Violate my order?
No, that wasn't a disciplinary issue.
Okay. Now, you described for us something about preferential treatment. You're saying that the LAPD department in this case gave preferential treatment by sending 4 detectives to O.J. Simpson's house on the early morning hours? Is that what you're saying?
No. First of all, I don't like the word preferential treatment.
No, that was the word used by the
Okay,
prosecutor.
well, anyway, I don't particularly care for it, but that had nothing to do with the number of detectives. The number of detectives were driven by the circumstances of that case.
All right. And you don't like that word because on the side of the police cars it says protect and serve all citizens, not just one or people who have a lot of money or people of any standing. Isn't that correct?
That's correct.
You're supposed to treat all people alike, aren't you?
We sure try to.
And fair to. You try to?
Sure.
Are you aware of what Phillips and Furman were doing at that scene between 2:30 and 4:30, the arrival of the robbery homicide detectives? Oh,
I don't have personal knowledge. I do
all right. You have no personal knowledge. The answer is no. You don't know.
no personal knowledge.
Per your order, even if they were off the case, per your order, you told them to go over and make that notification, didn't you?
That's correct.
And they didn't do that, did they?
Not
During that time frame.
during that short time frame, no, they did not.
2.5 hour time frame we're talking about?
That's correct.
And time was of the essence, according to you. Isn't that correct, sir?
That's correct.
Who made the decision for robbery homicide to take over this case?
I believe the decision was made by Captain Gartland, the commanding officer of robbery homicide. It's my belief that he agreed to take the case, although it could have had the concurrence of someone higher in his chain of command.
Do you believe that? You're not really sure about that, though.
I'm not really sure.
May I have just a second more, Your Honor?
Certainly.
In the course of your responsibilities that morning, were you more concerned about the department's image than you were about investigating these very brutal murders?
Certainly not.
You would agree with me that the most important thing was investigating these killings at that scene as soon as possible because of the importance of that. Isn't that correct?
One's not to the exclusion of the other, but what you just described was certainly a top priority.
Yes. And along with that would be complying with the state law and notifying the coroner. Isn't that correct?
Sustained.
May I have just a second? Thank you. Commander Bushy, from the time that you notified or told Detective Phillips to make this notification at about 2:30 in the morning, and we've already covered the fact at the time the notification wasn't made, would it be in direct contravention to your order to Phillips if Phillips and Furman were standing in the street at Bundy and Dorothy waiting for the robbery homicide detectives to come until 4:30 instead of complying with your order? Wouldn't that be in direct contravention to your order?
No,
That would not be if they were just standing in the street waiting?
no.
You've already said that would be disappointing to you, the fact they didn't do it on an immediate basis. Isn't that correct?
I think the disappointment was that it did not occur sooner. There's tremendous competing priorities at a scene of that magnitude.
Right. You keep talking about the competing priorities. Competing priorities are to investigate this homicide scene as thoroughly and in accordance with state law. Isn't that correct, sir?
Let-
Isn't that correct?
I'm not aware of a state law that regulates an investigation.
No. The state law regulates when you call the coroner. Are you aware of that? Well,
This was
all
beyond
right,
the
all
scope,
right,
counsel.
okay. This is in response to the question. You may not be aware of that, but are you aware that the most important priority is investigating these murders? Isn't that correct?
That's correct.
All right, that's more important than notifying somebody who's not the next of kin. Isn't that correct?
Those are not in competition with one another.
It is. It's argumentative.
Are you aware of how many police officers came to that scene and how many from your division in West Los Angeles that night?
No, I'm not aware of all of them that came to the scene.
If there were more than 30 officers, would that surprise you at all who came to that scene?
No?
All right. And of those 30, don't you think that one or two of those 30, other than the lead detectives, could have gone over and made this notification per your order to Phillips? Couldn't they? You can answer that.
You can answer the question.
They could have, but that would not have been our practice.
But you've already told us it wasn't specific that Phillips had to do it. Isn't that correct?
That's correct.
So they could have done it, right?
They could have. It would not have been typical.
And Phillips could have done it rather than standing around in the street for 2 hours waiting. It couldn't he have?
I think
No.
we've gone over this already.
I think you're right. Thank you very kindly. Thank you.
Ms. Clark?
Sir, as a police officer or detective on a scene, would it be fair to state that circumstances dictate your actions?
Would you repeat that question, please?
Yes. For any police officer or detective on a scene, would it be fair to say that circumstances have to dictate your actions?
Absolutely, and they're always different.
Now, if it's unknown who is ultimately going to handle the case, is it reasonable police procedure to wait for the person or detective that is ultimately assigned to the case to make personal notification?
Sustain.
What is the proper police procedure regarding who makes notification when it is unknown as to which detective or which agency will ultimately handle the case?
Which agency?
Which division?
We try very hard to make sure that the person who calls the shots is the lead investigator. And if there's going to be a handover, investigative responsibility from one entity to another, the entity that's relinquishing that responsibility always defers to the people who are going to assume responsibility for that investigation. It's very important from the standpoint of continuity.
Now, if the detectives are yet unsure as to the identity of a victim, would it be proper, based on a supposition, to go and make notification to next of kin?
If you did not know who the victim was,
If you were unsure.
if you were unsure, you wouldn't make the notification.
It would be important, would it not, sir, to make sure that you have correctly identified the victim before you go to notify that person's family, correct?
Absolutely, you wouldn't notify next of kin unless you know for certain that their loved one had expired.
And do you recall precisely what Detective Phillips' language was to you, whether he said he thought it was Nicole Brown or was sure it was Nicole Brown at the time you spoke?
Sustain. Sustain.
Your Honor, this was elicited by counsel.
Nope. Not as to who it was, no.
When you issued your order to make notification, Did you intend that it be followed whether or not Detective Phillips was sure that it was Nicole Brown that was the victim?
Sustained. It's irrelevant.
Would you expect any detective to make sure of who the victim was before he went to make notification?
Absolutely.
And did you assume that Detective Phillips would do that, sir?
That's a given. That would certainly be among the assumptions I would make.
And did you know whether Detective Phillips had ascertained for sure whether that was Nicole Brown at the time you spoke to him?
It's also speculation.
Sustained.
Were you aware of what Detective Phillips' state of mind was, or his knowledge was, with respect to the identity of the victims in this case at the time you spoke to him?
Sustained.
What did you know about Detective Phillips' knowledge of the identity of the victims in this case at the time you spoke to him?
Sustained.
Did you have a conversation with Detective Phillips about whether or not he was sure it was Nicole Brown at the time you spoke to him?
Or at the sidebar with the court reporter, please. Anything new?
Yes. In your experience, sir, notification to the family takes approximately how long?
Well, they usually take place after the investigators are through at the initial crime scene.
How long? Does notification usually take several hours?
No objection. This is also speculation.
Oh,
Each case is different.
Well, each case is a little bit different, and it certainly depends on the availability of the person being contacted. There are times when it's a knock on the door and there's a clergyman there, the family's there, and there are other times when it can be quite a laborious process depending on how many people are involved and the degree of grief that's experienced.
Now, I think you indicated before that one of the reasons that you asked that the defendant be personally notified first was your knowledge that he lived nearby.
I seem to recall that I was aware that he lived nearby.
So he would be easiest to reach, was that your thinking?
Yeah, that plus the fact that his children were there caused me to form that opinion.
So even though legally speaking, sir, he was not next of kin, why was it that you...
No, it's not.
Was that...
No, it's not.
No, thank you. I'm sorry, I couldn't hear you. Thank you. Even though legally speaking he was not next of kin, sir, you indicated that you felt it was important to notify the defendant first.
Well, that seemed to be the person we could probably get a hold of first, because the children being there, a prominent person, belief that he lived in that area, he seemed to be somebody who was accessible.
And the children, did they play a large part in your concern for notification?
Absolutely.
Did you go to the station the following morning?
Oh, hold on. This is
I
way
don't
beyond, wait.
I'm sorry.
This is way beyond the scope of notification at 2:30 in the morning.
It is the subject of notification.
Activities at West LA Station the next morning are not. Proceed.
Nothing further.
Proceed.
Thank you very kindly, Your Honor. Who told you that O.J. Simpson lived nearby?
You know, I don't recall specifically, and I've asked myself that question several times, but I'm trying to separate what I knew that night from what I've subsequently learned. And I had the sense, as a result of my conversation with Ron Phillips, that he lived nearby, and I can make an assumption if that's what you'd like.
I don't want you to assume.
Okay.
Let
I
me
cannot
ask
tell
this.
you exactly why I knew that.
All right. Could it have been that Detective Mark Furman told you that he lived nearby?
Oh.
Could
That
have been-
absolutely, no, that did not occur.
He didn't tell you that?
I had no conversations with Furman.
Now, you would find unusual that the two minor children that you were so concerned about would know who their father was and where their father lived, would you? Who were at the police station. That would be no mystery, would it?
No, what about the police station?
That you would not find unusual that these two minor children, Sidney and Justin Simpson, who were at West Los Angeles Police Station, would know where their father lived, would you?
You would think that they certainly would.
And what you've told us here today is when Ron Phillips talked to you at 2:30, he told you that one of the female victim in this case was Nicole Brown Simpson. Isn't that correct?
That's what he believed, yes.
By the way, you talk about these competing interests.
Objection, no motion to strike on hearsay.
Oh.
You talk about these competing interests. One of these competing interests is not standing in the street doing nothing at a homicide scene, is it?
If another investigator is responding to take over the investigation, that's probably the thing that they should be doing.
I'm talking about your competing interests, not about another investigator taking over. I'm asking you, you talked a lot about competing interests. And I'm asking you specifically as a commander with the Los Angeles Police Department. One of the competing interests at a serious homicide scene that needs to be investigated is not standing in the street doing nothing, is it?
Objection, it's argumentative and has been answered.
Sustained.
Thank you very kindly. I have nothing further.
Do you recall whether Detective Phillips told you he was sure it was Nicole Brown? Or maybe was it?
Hearsay.
Oh.
He was at her residence, and I'm quite certain that there was no conversation that he is absolutely certain that this was Nicole Brown Simpson. I believe that that's what it appeared to be because she lived there, but I'm quite certain that there was, well, I'm not certain. I'm not aware that there was a positive identification, but that's certainly what it appeared to be.
And you had no conversation with Detective Furman that night, correct?
None.
And you told that to Mr. Cochran earlier in his cross-examination, correct?
I believe so.
Can you imagine why he keeps mentioning Detective
Sustained.
Furman?
Sustained.
Thank you.
That's what this is my last question. With regard to the fact that the detectives were at Nicole Brown Simpson's house, her children were at the police department. Is that correct?
At some point.
Yes. They've been found at that scene. And Detective Phillips told you that she was the victim. Isn't that correct?
Objection, hearsay?
Oh.
Has been answered.
Isn't that correct?
Oh.
Our assumption was that it was Nicole Brown Simpson.
Otherwise, you wouldn't tell him to go give notification. You wouldn't give a direct order as a commander of the Los Angeles Police Department, would you?
That's correct.
Thank you, sir.
All right, Commander, thank you very much, sir. You're excused.
Thank you.
All right, ladies and gentlemen, we'll take our mid-morning recess at this time. Oh, I'm sorry, we had a stipulation. Mr. Neufeld, you had a stipulation to offer?
Can we take our break before we enter the investigation?
Uh,
Is there a problem with the stipulation?
No, but there's a common procedure with what case we're in. With those sort of, defense. I don't know whether you...
No. Offer the stipulation.
Thank you. Your Honor, if I may. Good morning. The prosecution and the attorneys for Mr. Simpson have entered into a stipulation. By the way, we need to have this marked. What's the next in order, Your Honor?
1382.
Okay. This should be marked 1382.
I don't know what the council's going to...
Yes, she,
I asked for it in writing. I didn't-
no, she didn't. And the
Ladies and gentlemen, would you step back into the jury room, please? Now, counsel, I realize that we're all tired and we wish this were over sooner than later, but this kind of petty bickering is not appropriate. And if you heard the snickering of the jurors as they were going out, they thought it was pretty silly, too. Now, is there a problem with the stipulation?
I don't even know exactly what it is, Your Honor. How can I say there's no problem?
Well, counsel, this morning, I was told, on the record, here in front of all of us, there was a stipulation. There was no objection from the prosecution side. It's reasonable for the court to assume that that offer of the stipulation had been made and had been accepted.
That is reasonable, Your Honor, and there was a stipulation. There is one. I just need to make sure that counsel is going to frame it in the way that we agreed. That means I need to see it in writing. Counsel's been told this innumerable times by Mr. Goldberg that that's the way we proceed in this jurisdiction.
You know, it's amazing to me.
Stipulation without knowing what he's going to say, Your Honor. How can I do that?
It's amazing to me that we have to bicker over a stipulation that this is a syringe used by the LAPD infirmary. It's astonishing what we've sunk to here. That we have to argue over waxing and waning. We have to argue over, and the waxing and waning goes to this side, the syringe goes to this side. This is incredible. This is just incredible for both sides. We'll take a recess for 15 minutes. If there's not a stipulation, then we'll have some more testimony, I guess. Thank you.
Please clear the courtroom.
Simpson matter. All right, have we resolved our stipulation?
Yes.
All right, do we have any other witnesses to present? What's our scheduling expectation for the remainder of the day?
If I may be briefly on Barry Sims, Your Honor, the notes that I promised the court are here. May I also indicate to the court that I have conferred with the members of the Simpson prosecution team, and we have determined that SOC B is not anything that addresses any part of the people's rebuttal case. We raised nothing in our rebuttal that would make SOC B relevant on surrebuttal. Furthermore, as the court is aware, the defense rested conditionally subject to the reservation of the Whitehurst matter. That's been resolved now, so there is no part of the defense case in chief that is left to be explored. So we neither have a proper admission in the defense case in chief nor on surrebuttal. Furthermore, the notes reflect that Henry Lee made extensive physical examinations of SOC B in April and in February as well. His diagrams reflect that the area to which they wanted direct testimony was located by him and examined microscopically by him. And certainly the April examination was not hampered by any faulty or inadequate equipment. If the defense thought this was so important, then clearly they had all of the knowledge they needed to put it into their case in chief and elected not to do so. And if I may proffer these notes to the court, or would you prefer?
Oh, I'd like to see the notes, and I'd like to see the photographs if they're available.
The photographs are in counsel's possession. I don't.
All right. Assuming the worst happens, and I determine that Mr. Sims is subject to recall, what's his availability status, Ms. Clark?
I actually called the Department of Justice Laboratory in search of Mr. Sims as the court directed me this morning. And I was informed that today is the day that he takes classes at the Berkeley campus in the extension school, I believe. And Mr. Konzak from the laboratory told me that he could not reach Mr. Sims and didn't expect him in the laboratory until sometime after 1:30.
I checked on the availability of Mr. Matheson. He's at school in Sacramento until Monday. And Mr. DeForest is teaching today until 3 p.m., and he's teaching tomorrow. So this would require testimony next week.
All right, then if you'll submit to me the notes from Dr. Lee, I'll take a look at them over the lunch hour. All right, then I suspect that all we have to offer the jury at this point then is the stipulation regarding the syringe. Anything else we can offer them as by way of witnesses?
I don't think so regarding the jury, Your Honor. May I just indicate to the court a couple of things on the list I have here? I think you might be able to do the rest of it.
Oh, no, we can do lots of things. There's 53 things we can do,
Okay, good, you know, okay.
not the least of which is instructions, motions on argument.
Right, we're going to ask you a couple of motions we can put, we can move up to the top, so some of us can go and start preparing. Thank you.
Okay. All right, then my inclination then would be to invite the jurors to join us, and as far as they're concerned, do the stipulation, then recess for the morning as far as the jurors are concerned. All right, for the day. Char, let's have the jurors, please. And let the record reflect that we have now been rejoined by all the members of our jury panel. And Mr. Neufeld, you have a stipulation to offer.
Thank you. The stipulation that the prosecution and lawyers from Mr. Simpson have entered into is that this exhibit, which is 1382, is a syringe that is the same make and the same model as a syringe that Nurse Fano Paratus used on June 13th, 1994, to draw blood from Mr. Simpson. And with that, Your Honor, I would ask permission to pass it around so the jurors can inspect it.
All right, it's in the original packaging, and there's no needle attached, correct?
No, there's a needle attached, there's a sheath over the needle, and there's packaging over the sheath.
All right. Hand that to juror number 14, please.
Thank you.
All right, the records reflect that each of the jurors has had the opportunity to examine that item. All right, ladies and gentlemen, at this point, we have no further witnesses to present to you this morning, so we're going to break a little early as far as you're concerned. And just to let you know what the progress of the case is, I now have before me certain motions regarding whether or not I'm going to allow either side to call additional witnesses as to certain specific issues in the case, and I have to decide who they can call and who they can't. I anticipate that we will conclude, as I indicated to you, the presentation of all the witnesses this week and argue next week, and that's still my expectation based upon what I know of the case today. So please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. As far as the jury is concerned, we'll stand in recess until given what I know about the availability of the witnesses, if I do allow them, they will not be available until tomorrow. So as far as the jury is concerned, we'll be in recess until 9 o'clock. As far as the counsel are concerned, though, we'll reconvene as soon as the jury has been escorted out of the court. All right, thank you.
Please clear.
I need a court reporter. All right, back on the record. All parties are again present. The jury is not present. Counsel, what I suggest we do is set up an agenda for the issues that remain to be resolved before we proceed to the instruction of the jury and arguments.
Thank you very kindly. Thank you very kindly, Your Honor. I think that's very appropriate. We would like to, in addition to jury instructions, we do have some further exhibits I think you're going to have to deal with.
Very few, though. I think
Very
we
few.
have
I think Mr. Douglas will be ready on that, plus whomever.
probably less than 20.
I think he has a sense of that. Your Honor, what I would like to, and I think Ms. Clark agrees with this, if we could this afternoon, or even now if you wanted to, take up the argument regarding the length of arguments in this case, perhaps first. Number two, Ms. Chapman will be down shortly to argue this, the motion regarding the use of both sides, the ability of both sides to use videotape that's been shown to the jury, and also videotape of the actual testimony in certain instances, which we would have an opportunity to preview and get ready. We'd like to take those two motions probably first. In addition to that, Dean Ullman is present, and as the court understands and realizes, we will undoubtedly ask for a further review of our earlier suppression motions in view of the attack on Mr. Van Adder's testimony. We think that issue is ripe again. We did not bring it up yesterday because we wanted to give you an opportunity to deal with Martz. Now that you resolved that, we think it's appropriate. We will be ready to respond to the people's request for judicial notice motion. And we have several other things that tie into jury instructions. The court will recall the page 4 staple incident. At one point, you had ruled, I believe, and indicated that the appropriate time for dealing with that would be in jury instructions, I believe. So that's something we think is very important to us. I've made a final proposal to Ms. Clark with regard to how we elevate this entire proceeding. I'd just like to say something, Judge. We're at the end of this trial, and early on you said to us that we wanted to conduct ourselves in a manner so that when this is all over, we could all go off and have dinner and would be proud of the way we performed in this trial. This has been very hard fought, but I'm hopeful that at the end we can come back full circle to that point. I hope that nothing has happened at this point will cause us not to do that. I mean, everybody's been vigorous. You've done your job. We tried to do our job on both sides, and I hope we can still do that. And I proposed something to Ms. Clark this morning with regard to what we do from this point forward, an argument which I think might help restore some of that.
Well, it's still my fondest hope, Mr. Cochran. As I mentioned, however, to your colleague, Dean Ullman, I suspected that at this point the invitation was only open to him and Mr. Hodgman, so...
I understand, yeah, and I said the rest of us will be trying to get back on the
dinner list.
invited list, Your Honor. We're trying real hard to do that. And I think that's one of the things about our system that makes it so great, that we can fight very hard, and we are very, very earnest in our various positions, and hopefully morally and ethically we'll try to do the right thing. But this is serious business from our standpoint, as you know, and from the people. We have a client that we've always felt was wrongfully accused, and so we've done everything we could to try and represent him. So, thank you, Your Honor.
All right, well, why don't we take up, Ms. Clark, do you agree with the order of taking these matters up?
Yes.
All right, then let's address at least the length of closing arguments and the use of video, if we can, this morning, and then we'll recess until 1:30.
I don't have any of my motions down with me. I didn't realize we were going to take that right away, so I would like...
Would Your Honor consider, we'd like at 1:30 to do those two motions. Would Your Honor consider, Dean Ullman is ready with that other motion, so we wouldn't lose any time. Would Your Honor consider that, the motion, the suppression motion?
At 1:30?
No, now, he can, well, you're not ready on that? Okay, no.
I do
Okay,
have
oh,
something
okay.
to argue, but we're not here right now. Everything's going to take a little bit of time.
Well, looks like a long lunch hour.
And at 1:30,
Although I must say that, you know, as far as our discussion of the instructions are concerned, we're about a day ahead of schedule, so. And it would thrill me to death if I could instruct the jury Friday morning, then recess, and then start our arguments on Tuesday. All right. 1:30.
What we agreed is we'll come back with Dean Ullman first, then we'll go right into the argument on time and the other two.
Okay, 1:30.
Please clear the courtroom.
All right, back on the record in the Simpson matter. Let's take up the length of argument matter first.
Your Honor, Ms. Clark is arguing that motion. I know she'll be here momentarily.
Your Honor, may
Length of argument?
I take care of a bookkeeping matter while we're waiting for her? I just wanted to make sure that the materials that the court considered on the Martz Whitehurst issue were made a part of the record at some point, because I know you reviewed things that we have not seen.
All right, then let's take up the use of video matter. Can we do that one, Ms.?
That was Ms. Chapman.
All right. Ms. Chapman?
Good afternoon, Your Honor.
All right, good afternoon, counsel.
Would Your Honor like me to address the people's response? Because you've read my moving papers. Well, okay, I'll just start from the beginning. The defense
Well,
would
let me
like...
just ask you this. Don't you think there are some restrictions we ought to apply to snippets or whatever it is that you're going to use to require that it not have... I noticed that from time to time, the camera looks at people in the audience or goes to things that are not specifically the witness or the person who's doing the questioning.
Yes.
Some reasonable restrictions.
Yes, we would not seek to introduce any videotape that had anything other than the witness. We would never want to pan over to Mr. Simpson or any other person in the courtroom. So we can make that assurance to the court that the only videotape of a witness testifying used would be that of the witness's face and demeanor. Okay.
Any other comment? Do you have any? Have you prepared any examples of what it is you want to show?
Well, the people talk about in their response that they think that there would be an undue consumption of time in arguing the admissibility. First of all, I've spoken with Mr. Cochran about this, and he intends to only use about 10 snippets of videotape in closing argument. So I don't think that there would be an undue consumption of time in having the court preview the videotape that we intend to use. And I don't believe that Mr. Cochran intends to use any videotape that's going to be considerably lengthy at all in any event. So I think that if we were to set up a time where both sides could be here and preview the videotape that the defense intends to use and that the people intend to use, if at all, that it wouldn't take very long at all. We could possibly do that Friday afternoon.
Do you believe you'd have those available by Friday?
All right, maybe, if I might just have a second.
Mr. Cochran says realistically by Monday afternoon, although I know that that is a court holiday. I don't think it would take very long.
All right.
The people also talk about in their response the turnaround time that they would need to respond by way of videotape. I think that the need to do that would be obviated also by having this preview session. they would then be made aware of what the court's rulings would be with respect to whatever videotape was admissible at closing argument, and then they would have enough time to present to counsel and to the court what videotape they plan to use in their closing argument. So all of that would be before the time for the closing argument. They also speak about taking testimony out of context. I don't see that as being any different from reading from portions of a transcript during the closing argument. Obviously, counsel takes certain portions of the transcript, and the people are obviously able to respond in the manner that they feel necessary in their rebuttal. Further, the people say that the videotape is not an accurate representation. I think that it's clearly the most accurate representation of what occurred at the trial. They speak about the angle being non-representative, that the camera is in a different position than the jury view. I think that it's very close, very similar, and I don't think that that should be a reason that the court should not allow the use of videotape. I think that I have addressed all of the arguments the people presented in their response, and I'm available to answer any questions the court may have.
All right, thank you, Ms.
The last thing I just want to say is that we looked up California law. There was nothing on the subject, but I did find some out-of-state cases, Illinois court, Indiana, and Georgia. All of them say it's basically at the court's discretion, and there are a number of cases which have allowed the use of video and audio tape in closing argument, as well as graphics, obviously.
All right, thank you.
Thank you.
Ms. Lewis,
Good afternoon, Your Honor.
good afternoon.
Your Honor, every criminal case in this country has been argued and is currently argued and will in the future be argued based on the court record in the case and perhaps illustrative charts that either side may use. In this courtroom, we're particularly fortunate for this case to have use of the Elmo and the graphics presentation that has been made available to the court and to counsel for both sides throughout the trial, in which we'll continue to have 4 closing arguments. That alone is a unique feature of this trial that is not enjoyed by the vast majority of criminal cases that are argued throughout this country. Now, when it comes down to the particular media videotape and broadcast, there are definite problems with it. And frankly, one of our concerns is that whatever the defense may choose to use, may be taken out of context. Now, when you're talking about a reporter's transcript where the arguing counsel has to cite the page and line, it's easy in most cases, though in this case actually with 200-something volumes, it wouldn't be as fast. But normally in the normal criminal case, it's easy to pull out the transcript and see what the context was in. We don't have that quick turnaround ability here. Even if we were given some amount of time to preview what Mr. Cochran, and I assume he's the one who's going to argue, intends to use, and anyone else who's going to be arguing on the defense side, even if we had the opportunity to preview that, we would have to, there would presumably, because there usually has been throughout this trial, there would be reason for objection. We would be making those objections. It would take us time to find the context. We might make representations to the court, but we'd have to go back and look. And frankly, it's difficult, especially with the, we're grateful for them, but they are government videotapes that we have. We don't have counters on any of our videotapes, so that it's, on any of our video equipment, I mean, our VCR playing equipment upstairs.
You're kidding.
No, we don't. I was shocked when I first discovered that, but unfortunately we don't. So it's very difficult to search through, as you can imagine, because you have to stop and listen periodically to what's being testified to, and it's a very, very difficult process, as we're discovering at the moment, to find things on the videotape. So the practical difficulties are going to create problems. In addition, there are some other difficulties.
So are you suggesting that the prosecution is at some kind of technological disadvantage in this? I mean, do you have access to the same tapes that the
We have
defense
access
has?
to the same tapes. No, Your Honor. I'm just suggesting that it is a practical difficulty when you're talking about videotape testimony, to go through and find the context that the defense may cite with regard to any particular witness's testimony. In addition, throughout the broadcast of this trial, as the court just mentioned, there are many times when the camera is focusing on other counsel, on the court, on members of the audience, on the defendant's face. And even though defense counsel concedes that that would not be appropriate to show, there are instances where that happened when the witness was giving critical context testimony. In addition, in recent months in particular, for a good reason I'm sure, the stations who have been broadcasting have been cutting away frequently to commercials, because I understand their revenue was down when they had high ratings but no commercial time. So there are many times now currently, which I don't know if the court's aware of this since you're in here on the record, when they're breaking away to commercials.
You promised we won't show any commercials in the closing.
And, Your Honor, the point of that is that we may not have a context. If the defense comes up with what we believe are misleading clips, there may not be a context available from the live broadcast readily available for us to supply the context.
Well, Ms. Lewis, let's suppose that as one of the requirements, I've already indicated that a likely restriction would be that the videotape would only be of the witness testimony only, no other views allowed, that these would have to be previewed, and any preview was likely to require a citation to the transcript as to where it's coming from, so that both sides have the ability to look forward and backward, and both sides have the advantage of having the real-time transcript on your computer disks. You can do word searches back and forth. I mean, it's pretty easy to find. I mean, that's why I've given you all this
And
fancy schmancy stuff.
all of that is wonderful when it comes to the record. And as most attorneys rely on when it comes to closing argument, we all rely on the record when we want to quote what a witness has said. The media broadcasting is not part of the record in this case. And for the practical difficulty, which I mentioned, in terms of searching the videotape, searching the disc is not a problem. But to have the jury presented with something that a witness has said out of context, and then to stand up here and dryly read the context testimony, or even put the context testimony in writing on the Elmo, doesn't make up for their advantage, that side's advantage in having shown the live testimony as to the point the defense wanted to make critical. Now, there's some other problems in it as well, as which I've set forth in the brief, so I won't go on at length. But the angle of the camera is at a high angle. It is higher up in the courtroom and points at the witnesses in a downward angle and quite to the side, so that the demeanor observed by the lens is not the same demeanor that these jurors who are sitting either lower than the witness or substantially level with the witness enjoyed. So that the demeanor is not even the demeanor that was had on the record, if there could have been a record, in terms of the eyes of these jurors and what they saw when they looked straight across at the witness testifying. It's not the same angle, so it does not portray the same image that these jurors captured in their mind's eye. So it's not a truly representative angle. And it reminds me of, I'm not that big a sports fan, but in football games I know there's been quite a bit of controversy over use of the instant replay, because depending on what angle is captured, something may or may not appear to have been so. Now, this is less important when you're talking about a person talking, but it still demonstrates the point that it is a different perspective from what the jurors had. So it doesn't necessarily at all record or be the best recordation of that witness's testimony. So, and Your Honor, we've heard throughout the course of this trial from both sides on what everyone's intentions were. And intentions when it came to witnesses, and intentions when it came to who was going to be called by either side. And Ms. Chapman makes the point about Mr. Cochran's intentions at this point in time. Suppose after the people's opening argument, perhaps Mr. Cochran might want to change his intentions with what he uses. That would consume time throughout the trial and throughout the closing argument and during argument. There's additional practical considerations. We're not ready to preview if the court does allow this. The prosecution is not yet in a position to be able to show the other side what we have, and I can't even make an accurate representation yet to the court in terms of when we would be able to do that. Monday is a Jewish holiday, and the lead prosecutor in this case needs to be here for something like that, and that would certainly be unfair of the court to require any preview be made on that particular day. So that there are a lot of practical problems, Your Honor, and we do enjoy, as I mentioned, the benefits of this elaborate graphics presentation system through the Elmo and the monitors to the jury, and that can be effectively utilized as well as all the traditional means, and as well as any videotape which was shown during trial and was entered as an exhibit. Any evidence that came into the case as evidence, of course, they can use the visual equipment to portray that. So both sides will have the luxury of, if there's any videotapes they want to display, of having that ability of displaying some live action, for lack of a better word, to break up what might be a monotonous argument by doing that. So the practical problems clearly outweigh any usefulness that this could have. In addition, Your Honor, it's very likely, given the number of witnesses we've had in this case and the vigorousness with which it's been litigated on both sides, that this would prolong the length of closing arguments for both sides, not only in litigating what's going to be used and allowed to be used, but in the actual presentation of these things, because they'd have to be explained and set up in advance as to what the witness was saying at the time. And the court, I know, is eager, as are the prosecutors, to get this case to the jury. That is our foremost consideration. And this is something with regard to closing argument that has too easy a potential to be misused. We do not enjoy practical ease in terms of the technology or the turnaround time with which we'd be able to glean the context in situations where the defense might want to use it. And the court, I submit, the court's exercise of discretion should be in favor of not allowing this for either side. It's simply not necessary and it could easily cause prolonged litigation, undue consumption of time, both before and during closing argument.
All right, thank you, counsel.
With respect to Ms. Lewis's concern about the practical aspect of this, it seems to me that it's far more practical to preview the videotape than it would be in a normal closing argument situation where counsel would simply refer to reporter's transcript and then opposing counsel would have to look up the transcript at that moment without any prior warning at all, except for at that moment's time. In this manner, we're going to have a day before closing arguments where the people will have an opportunity to see everything that's going to be presented. So it's going to run much more smoothly than it would if simply a transcript were used.
But Ms. Lewis does raise the issue that we have agreed to be in recess on the 25th.
It's my belief that this preview session is not going to take very long. I really don't anticipate that the defense is going to use a great deal of videotape. I don't expect that the prosecution is going to use a lot of videotape since they're opposing this motion. So whenever we do it, I think it can be done in a short amount of time. We can do it first thing Tuesday morning.
When do you anticipate your side would be able to isolate those passages, at least by reference to the reporter's transcript? Say by 5 o'clock Friday?
Yes. By 5 o'clock Friday.
All right.
Okay. With respect to Ms. Lewis's arguments regarding the angle, Mr. Blazier points out that each of the jurors had a different perspective from one another. So I really don't think that that is of primary importance. And it's also interesting that the people are arguing about the time limits in closing argument. It was the defense position that closing argument itself should be limited in terms of time, and the prosecution wants to have an unlimited amount of time to argue. Obviously, since we're arguing for a limited amount of closing argument time, then we would fit our videotape into that amount of time. As I've emphasized over and over in this argument, we don't intend to use a lot of videotape. I don't think it's going to take a lot of time for the court to preview, and I don't think it's going to take a lot of time in closing argument itself.
I suspect that all 10 of these snippets aren't going to come as to any surprise as to which 10 they are.
I don't think so.
I don't know if there's exactly 10 in that range, yes, because I think you can probably guess.
I could guess as to which, I can guess at least as to 6 or 8 of them.
But it seems like we should cross this bridge almost when we come to it. The court is going to have to make a determination at some point as to what is appropriate with respect to the exhibits and graphics, and we just like to put the video and audio tape along in with that. Obviously, if the court finds something inappropriate in any of the graphics or demonstrative evidence or videotapes, the court will say so and rule that to be inadmissible. So we're asking for an opportunity to preview to the court and counsel what we intend to use, and then the court could make its ruling at that time.
All right, thank you, counsel.
May I make a couple of additional points, Your Honor? Please, briefly.
If it's absolutely necessary, Ms. Lewis.
We don't have all of the tape proceedings in this case. We have made a valiant effort to do it throughout the trial, but there have been times when equipment's malfunctioned and other times when we simply didn't do it. So not only is there a practical problem from our point of view in locating context and so forth, but we may not even have the tape, even if assuming there was live coverage. And there's an additional point which I did raise in my brief that I wanted to mention, that there are many instances where well, I think in every instance, if I'm not mistaken, the logo or channel number of the broadcaster is visible at some portion of the screen, which would have to be excised out. It would be inappropriate to draw the jury's attention to the fact that the media has been broadcasting this. I know they're aware of it, but that would only heighten it when they're staring at a witness, since they're not allowed to watch television coverage or anything like that when they're back at the hotel, since they've been sequestered. In addition, there are comments that appear in much of the live coverage beneath the witness, just a description of what they're testifying to or some context, which is perfectly appropriate in terms of the media providing entertainment to their viewing audience, but totally inappropriate, again, in terms of appearing to have some kind of official endorsement because of the professional manner in which it's displayed of any description of the witness. May I have just a moment? In addition, if any of the footage that's used is news coverage of the any portion of the testimony, as opposed to the Channel 5 or CNN or Court TV's live broadcast, that too is going to be demonstrated by whatever it is that's on there with the symbols and the statements and so forth. And of course, that would highlight totally improperly whatever that news organization felt appropriate to show that day. That would give it extra emphasis or extra authority or extra deference that the jury, of course, is not allowed to give it, and that would be a distraction as well. There's a lot of practical problems from our humble points of view as civil servants with I know there's a lot of us on this case, but we still have limited abilities and limited technology and limited dollars, especially to spend on something such as closing argument when we do have these wonderful courtroom graphics available to us.
All right, thank you, counsel. All right, the request to be allowed to use videotape, quote-unquote, snippets of testimony during the course of argument will be granted under the following terms and conditions. The snippets or the outtakes that can be used may depict the witness and the witness only, that it must come from videotape that is available to both sides, that the defense should file by the close of business Friday, which I will deem to be 5:00 p.m. on Friday the 22nd, the transcript citations of the excerpts that they wish to use, because the prosecution has technical disadvantages. Apparently, I'll allow them to leave until Tuesday morning the 26th to submit their citations, no, counsel, to the transcript, and we will have the screening of the snippets or any outtakes in reference to the transcript at 8 a.m. on Tuesday.
And Your Honor, you said file by 5 p.m. Did you mean to indicate as well the defense should fax or somehow supply a copy?
Yeah, well, I assume you all still will be here Friday afternoon.
We will.
All right. All right, but the court will preview each one of the outtakes that are to be used.
Thank you.
All right, thank you, counsel. All right, length of argument. I thought
Was Mr. Yeoman trying to catch a plane out? Perhaps he would enjoy doing the motion to suppress.
No, I'm here.
Your Honor, we are endeavoring to get Ms. Clark down here immediately.
Okay, no, I mean, I thought we had agreed on the order of our discussions, that the length of the argument was going to go first and then the videos. All right, well, let's move on to the additional motion to suppress. All right, good afternoon, Ms. Clark. Are you prepared to go forward with the length of argument discussion? All right, Mr. Cochran.
I think it's kind of poetic justice that as I stand before you to argue the length of motion argument for closing argument, I want to make this a short argument. I think that's very appropriate. Our papers, I think, bespeak what we're talking about here, Your Honor. We've all talked to them for 2 or 3 days based upon some idea that this case is complex. They've heard the evidence. You've said so many times, Your Honor, these are smart people. They've heard the evidence. Certainly, we hope they've kept an open mind, but they know what they feel about all these witnesses at this point. I think some of your recent rulings have tried to tell us enough already. And that's really the theme that we picked up here from you and from the jury. It seems that everybody understands that except the prosecution. And so toward that end, we've said, given this case, given all of our experience in trying cases, we believe that we should be able to concise our arguments, even with videotape, into one full day, both sides. Where if Ms. Clark starts to argue on Tuesday, she has from 9 until 5 or whatever hours you said. If we start to argue on Wednesday, we have a like amount of time. In fact, I think what we really are saying is that she has perhaps a little bit less than we do because in the total of her argument, it's going to come to the same amount. In other words, she wouldn't have all day Thursday to try and rebut what we do on Wednesday. That would be unfair. I think we'd all agree. But at any rate, what I'm concerned about is that she gets up and tries to argue for like 2.5 days. And then let's assume that she does that. Let's assume that they're unwise enough to try to argue for 2.5 days next week. We would then be to Thursday afternoon. You're going to be dark on Friday and Monday. What are we to do? Start my argument on Thursday afternoon and then come back on Tuesday? I want to tell you, I had that experience during an opening statement. That's not fair to Mr. Simpson or to the jurors. And so I think
That might be ideal timing for you, because you could leave them with the last thought over a long weekend.
well, if I thought I could finish it in a half day, that might be ideal timing. But I think, Your Honor, we need a little more than a half day. So what I'm asking really is just some fundamental fairness at the end. And I'm asking you to do what you've done so very often in this case, is use your discretion. This is an area of discretion. You want to protect these jurors, and that's all we're saying. We're not trying to dictate anything anybody does. Because in the final analysis, we have to use our own good judgment. And I think Ms. Clark will do that also. But it seems to me, as very often in this case, we need some guidelines to help us use our good judgment. And all I want is fairness. You know her rebuttal argument is limited to rebut what we have. So if you give us a finite amount of time, if we have 6 hours and she uses 5.5, then she's going to be left with only a half hour at the end. So I think that's the way it should be carved out, and I think that's fair to everybody. I just venture to guess, if you submitted this to the jurors, they'd probably ask for less than a day of argument if it was left up to them. And so I think we have to have them in mind. After all, this is supposedly for them, to tie this case together. We welcome this opportunity, but I think we have to make the most of the opportunity. And in order to make the most of the opportunity, it seems to me we do it in a concise, cogent, persuasive fashion so these people get the message. And that's all I'm really asking. And so specifically we ask that the arguments be limited to 1 day per side, that we understand what's going to happen, and we get this case to the jury by the end of Thursday, September 28th, 1995. This case goes to that jury. And we want to be part of that, Your Honor.
Thank you, counsel. Ms. Clark.
Thank you, Your Honor. We filed a brief with the court in response to this request, and I found it interesting to note that there was case law in the area. I didn't think there would be. People v. Green, it's almost 100 years old. But it has been a recognized principle for over 100 years that the length of argument has to be governed by the length and complexity of the case. As the court has seen, this is a very complex case, made more so by the manner in which it's been tried. It's a physical evidence case. This court knows very well the complexities of a circumstantial evidence premised on physical evidence. We have had enormous amounts of scientific testimony. We have had testimony from a number of experts on each area of physical evidence, blood, hair, fiber, as well as the coroner. It's been extensive. If it was the intent of the defense to get this case quickly to the jury, then the defense did not have to spend almost a week talking to the jury through their expert about the movement of an envelope a few inches because the coroner moved the body. If the defense wanted to limit the time that it took this case to get to the jury, it did not have to question Detective Lang for 8 days on cross-examination. If the defense wanted to limit the time it took to get this case to the jury, it did not have to question Dennis Fung for 9 days. As the court has seen repeatedly, our witnesses have been subjected to the most thorough, blistering cross-examination I have ever seen in 17 years of practice. It has been lengthy, it has been detailed, and I suppose reasonable minds can differ as to whether or not it's been overdone. Be that as it may, many, many issues were raised. We bear the burden of proof. It is very clear that the reason for the defense wanting to limit closing argument is to gain what they perceive to be a tactical advantage. I understand the tactical advantage that they want to achieve here. The defense says that they can tie their case together in just a few hours or maybe a day. That's because they have very little to tie together, Your Honor. This was not a thematic defense in terms of evidence.
I see you're arguing already.
Yes. Well, it is an argument, Your Honor. Argument about an argument. Only in this case.
Only in this case.
It's true. I think.
No, I mean, that's not true. I mean, in other cases, I've talked to other judges, judge who handled the Night Stalker case, judge who handled the Martin case, judge who handled the Denny case, and we've all discussed whether or not it's an appropriate exercise of the court's discretion to limit argument. So your basic argument is it's not fair because it's our burden of proof and we have a lot of stuff to prove.
Yeah, that's right. We're the ones that have a lot to tie together. We're the ones that have literally mountains of evidence to weave together with the testimony of lay witnesses concerning motive and opportunity to present as a cohesive fabric to this jury.
But isn't it a very powerful argument that the defense makes that this court should do everything it possibly can to encourage counsel to be precise and concise in their argument, and that a time limit would cause both sides to evaluate what it is that's important in this case and what isn't, what the big picture is, and not get lost in the minutia of 12 days of argument?
I agree with you, Your Honor. I don't think the court needs to worry that the people are going to get lost in minutia. We're professionals. We don't attempt this at home. We are going to make every effort to be as concise as we can. We know that the jury is tired. We know they don't want to hear a lot of words. We know that the best thing to do is get it to them as quickly as we can.
All right, Ms. Clark, taking into consideration the length of the trial, the complexity of the case, the number of witnesses that you've called, the burden of proof, what do you think is a reasonable amount of time for the prosecution for opening and closing arguments?
How can I possibly estimate that, not knowing what the defense is going to do or how long the defense will take,
Well,
what they'll go into?
What do you think your opening argument is going to be?
How long will it take?
Yes.
I can't. You know, Your Honor, it's unfair at this point. We have not, as the court knows, there's going to be graphics. You know, there's going to
Ms.
be,
Clark,
I can't.
Let me put it to you this way. You know, we discussed at the very beginning of this case limitations on the number of counsel who will argue, and that the court was contemplating a limitation on the arguments. So you should have some rough idea of how long you believe it's going to take.
Very rough. I don't know. The opening portion of the People's case would probably take roughly 2 days. And I don't think that's a long time considering the amount of evidence we have here, a circumstantial evidence case. The problem that I really have is estimating the amount of time on rebuttal. I mean, you're asking me to estimate in a blind. I don't know what they're going to do.
No, that's why I confined my asking you to estimate to your opening argument.
I mean, that's a very rough estimate without having paced through it with the exhibits and laser boards.
And I assume that your colleagues will assist you in marshaling all the exhibits. And I've indicated to you that my staff will be available to both sides to organize. I mean, we've prepared Mrs. Robertson's list of exhibits, and we will do everything we can. All of my law clerks will be standing in the wings with exhibits. You ask for the exhibit, and it'll be produced.
And I appreciate that, Your Honor. That will be very, very helpful to us. But a large part of the presentation will involve graphic displays that will not involve the court's cooperation. although we do accept it as the very gracious offer that it is. I would also indicate to the court that the real, I think, intent of the defense motion is to limit the rebuttal by the people. What they'd like to see is their case, their presentation, not attacked as thoroughly as it can be and will be. And that's the limitation they really seek. And that's what would be so unfair. I've never tried a case where the court has imposed a time limit, and I'm not saying that that's precedent for anything. All I'm saying is that I have never, over-lengthy arguments have not been my problem with juries. And I don't intend to break that habit now, given the fact that the jury is tired and we don't want to tax them more than we already have. I think that the court can trust me when I say absolutely that we will trim our sails and be as tight and concise as we can possibly be. But to impose a time limit in a case that has already gone this long with this much evidence produces an unfair burden only to the people. This is a motion that is punitive really only to the people. The defense can get up, raise questions, confuse evidence, misstate testimony that quick. And in a case of this complexity, it's easy to do. Create the confusion and the distortion. It takes something for the people to unravel it and put it back together and put things in their proper context for the jury, and to limit our ability to do so is nothing less than limiting the people's right to a fair trial, limiting our ability to explain to the jury how the evidence has overwhelmingly proven the defendant's guilt. And there can be no justice in that. In what the people propose, we don't propose to limit the defense argument. We propose that the defense take as long as they think they need for their argument. And let me remind the court that the people's opening statement was shorter than the defendant's, even when you put it all together and you take out the delays. So we have precedent here for the manner in which the people present their case. And all I'm asking from the court at this final 11th hour is please give us the chance to pull it together for the jury. After all of the obstacles that have been put in our way with things that we could never have anticipated, we need the opportunity to explain this to the jury in an unfettered manner and to be trusted as professionals that we are, that we will not abuse the jury's patience too much.
Good afternoon again, Your Honor. Your Honor, I'm certainly not going to be personal and talk about misleading and distorting and all that stuff. I want to elevate the discussion. This is not about one side or the other. This is about this search for truth, Judge. And, as we said before, Ms. Clark stands before you and says, trust us. We're going to get this case over with real quickly. They're the same people who trust us, and they took 8 months to put their case on. They talk about 8 months, we had 8 weeks, and they're talking about our cross-examination. So, Judge, you can trust us all you want. I'm saying trust us, but give us some direction and some guidance. That's why you're the judge, and you have not been bashful about doing that. One thing I'm concerned about, Ms. Clark kept talking about graphics. We haven't seen any graphics. I think there must be some. The real reason I'm back up here is we want to see their graphics, obviously, as early as possible before they start, because we're entitled to do that. And she's talking about displays and various things. When are we going to see those? And so I hope the court will take care of that. Let me get to her response. There are complex cases. The World Trade Center case. The judge in that case is giving the lawyers a time limit, 4 hours. We have this all the time. Judges give you, say, counsel, you have 4 hours to finish your argument. You have 2 hours. You have 1 day. This is not unusual at all. Lawyers don't stand up before you and say, please don't do this to us, Your Honor. The people are being punished. Lawyers deal with what they're dealt with. When you ruled this morning, you didn't see us crying. We just moved on to the next issue. We don't do that. That's what a professional does. You move forward.
Most of the time.
Well, sometimes. Well, one time we did cry, Your Honor. I have to admit, there was one ruling that made us cry a little bit. But short of that, you have to admit, throughout this whole trial, we have usually moved forward in the water like a shark, and that's what we want to do.
That's a bad analogy.
Well, not a good analogy. Shark's probably not a good analogy. We moved forward in the water like a dolphin. Graceful, I hope if that's better. But seriously, Judge, we don't stand before you asking, it's not a question of doing a favor for the prosecution, doing a favor for the defense. This is about 14 people who get $5 a day, who've been here, Judge, since September 26th, 1994. I don't have to tell you that. Tuesday will be the first anniversary. We went upstairs and met these people. We promised them certain things. And we're lawyers. We're professionals. Let's get this case over with. It's not any advantage we're trying to get.
If she argues 2 days, I could argue 4 days. I feel so passionate about this case, I could argue from now on. I just have to concise it. This is not trying to shorten anything. She hasn't seen passion yet. I told them once before, they're in the fight for their lives, and now they understand that. And we're going to argue in that same vein next week. Doesn't matter whether I argue 1 day or 1 week. They'll understand how we feel about this man's innocence. So it's not about time. I'm just asking you to step up, give us some rules, we'll abide by them. That's all I'm asking. But for heaven's sakes, give us, we want some time to see those graphics. Thank you.
Others. All right. Thank you, Counsel. Counsel, in contemplating limiting the argument here, I had to take into consideration a lot of things. First of all, the unique facts and circumstances of this particular case, the conduct of the lawyers in their argument to date, the length of time that this trial has gone on, and the increasingly limited endurance of our jurors. The court's experience, I had to go outside my own experience to talk to other judges to see what their experience has been and to hopefully gain some wisdom from them. And in discussing the matter with Judge Tynan, who tried the Night Stalker case, which went on for 8 or 9 months, discussing the matter with Judge Pounders, who tried the first McMartin case, which went on for almost 2 years. And if I recollect correctly, Judge Tynan's case involves 17 counts of homicide. Highly complex issues involved in that case, and just pulling together all the evidence. And my own experience as a trial lawyer. And I recollect one argument that went on for 4 days, where the defendant was charged with 5 counts of murder in a circumstantial evidence case. But I also watched the jurors' eyes when I was arguing to them, and that's one of the great benefits of attorney arguments, is that the argument is to the jurors. And when you're arguing to the jurors, you look at them eyeball to eyeball, and you can tell when they're being receptive, hopefully, and you can tell when you're boring them or when you've just said something that they don't believe. That's one of the great advantages of argument. I'm very concerned about maintaining control of this proceeding, especially at this point, given the limited endurance of our jury, and I am sorely tempted to impose a time limit, but I am not going to do so. And I'm going to trust the lawyers. But by having said that, I will come back to the start of this argument with probably 3 good nights of sleep, so I'll be on the top of my game as far as staying on top of the lawyers. And I will make sure that there is no redundancy and that we keep moving. And I will not hesitate to call you over to the sidebar and tell you to get moving or move on to something else. And I won't hesitate to do that also in front of the jury if I feel it's appropriate. So be prepared, be ready, be concise, knowing that I'm unusually tolerant of lawyers, but this jury is going to have the last say. All right.
Can we inquire about the graphics and how we're going to see those? And
That's another issue, counsel.
Okay. Okay, I understand.
Another issue.
We need to know about that. And also, would I just, as a question of point of information, if she, Ms. Clark does take, let's say, 2 days, then there's a chance there will be a break in our argument.
I understand that.
We're setting concrete on the 29th.
Unfortunately, we are.
Okay. Very well.
When I made those plans, I had no idea we'd still be here
I'm not asking you to change the plans. I just want to make sure that we knew we were
a
doing.
year later.
Yeah, understood.
Okay. Now, those are plans that were made a year ago.
We've got cases we have, right?
All right, 1538.5.
Yeah, about the graphics? No, we don't have our video snippets either, but you guys want to see them, so I want to know when we can see them.
We'll see them before they're used.
Can we see them Friday afternoon or at 5 o'clock?
Tuesday morning, 8 o'clock. Tuesday morning, 8 o'clock.
8 o'clock Tuesday? And that's the time to see them and project and that sort of thing?
This is the whole enchilada. Be here at 8 o'clock.
Is that for everything?
Snippets, boards,
Everything?
everything.
We have till Tuesday, 8 o'clock, thank you.
Right.
And that vacates the 5 o'clock Friday? Is that right?
No, no. I want the transcript notations.
Okay, all right. Tuesday, 8 o'clock, thank you.
All right. Mr. Ullman. Good afternoon.
Good afternoon, Your Honor. Your Honor, at this time, the defense would move to reopen the motion to suppress the evidence seized without a warrant from Mr. Simpson's Rockingham residence on the morning of June 13th, 1994, and all of the fruits thereof, so that this court can consider the testimony received yesterday from Detective Van Adder, from Special Agent Wax, from Larry Fiato and Craig Fiato, as relevant to the motion to suppress. This motion, of course, is based on the same grounds of newly discovered evidence that we asserted with respect to the evidence related to the credibility of Detective Furman. I believe it raises essentially the same legal issues, and we believe that the testimony that Your Honor heard yesterday was not only relevant for the jury in assessing the credibility of Detective Van Adder with respect to the testimony they heard, but of even greater relevance for this court to consider in assessing the reasonableness of the entry to the premises on the morning of June 13th, 1994. Mr. Kelberg posed the question yesterday, what reason would Detective Van Adder have to lie about when O.J. Simpson became a suspect in this case? And the answer to that question goes back to the motion to suppress that was filed in this case in late June of 1994. A motion that created a need for a cover story and a need to stick with that story throughout these proceedings. The first explanation that was ever given of the discovery of the glove is found in the affidavit for a search warrant that Detective Van Adder executed in the morning hours, sometime between 7 and 8 o'clock in the morning on June 13th, right after the glove had been discovered. And it's ironic that among all of the misrepresentations and untruths contained in that affidavit, there is one kernel of unvarnished truth. And that was the statement, while securing the premises, the officers discovered a glove behind the Simpson residence. That the discovery took place in the course of activity that involved the securing of a residence, which suggests that they were engaged in a search at that very moment. And the initial issue we raised in the first motion to suppress, simply based on the representation contained in that affidavit, was that police are not entitled to secure premises until they have probable cause to make a search. So it puts the cart before the horse for the police to say, while we were securing the premises, we found the evidence that we believe now gives us probable cause to get a search warrant to search the rest of the residence. And that's what created the need to come up with another story, another explanation. And that was the first time we heard the explanation that, well, we really didn't go to the premises in order to look for a suspect or look for evidence. The only reason we went to those premises was to notify Mr. Simpson of the death of his former wife and to make arrangements for the disposition of the children. That Mr. Simpson did not become a suspect until we found the glove. Now, that's not to say that there was any legal necessity for them to deny that Mr. Simpson was a suspect. Legally, if an officer has a subjective suspicion of a suspect, that doesn't invalidate otherwise reasonably objective circumstances that create the necessity for a warrantless entry. But the real crux of the relevance of this evidence with respect to the credibility of Detective Van Adder is the inconsistency that it creates in the entire explanation of what was going on that morning, of what the officers were really up to when they went over the wall and started looking around the premises of Mr. Simpson's home. And when you put the context of what they actually did against the alternative explanations, I mean, we have two alternative scenarios here. One is O.J. Simpson was not a suspect. We were only there to make a notification, to make arrangements for the children, and once we discovered that speck on the door of the Bronco, to make sure there weren't other victims on the premises or people who needed assistance. Versus the explanation of what's really going on here is a search. We're looking around for whatever we can find because we want to solve this murder. And the obvious suspect, right off the bat, right off the beginning of this whole process, is O.J. Simpson. If you look at how they conducted themselves once they arrived at the premises, it's much more consistent with the scenario of a search than it is the scenario of a notification. The way they entered Mr. Kalin's room, searched the room, looked through his clothing, the way they questioned the persons who were on the premises, the amount of time that they spent on the premises before the glove was even located, actually entering the premises shortly after 5 a.m. and then finding the glove more than an hour later. The quickness with which they were able to ascertain where Mr. Simpson was and to actually call him and speak to him and notify him. And the glove actually being found after that had occurred. The fact that they didn't even look upstairs. I mean, if their real concern was, we're looking for other victims, the fact that they didn't even go upstairs to see if there were any victims upstairs. All of this activity...
But couldn't that also be argued that if it wasn't intended to be a generalized search for evidence, if they didn't even go upstairs? That's what the prosecution's going to argue.
Well, question whether they possibly did go upstairs, but the fact that they're saying we're doing an overview of the premises to look for victims is hardly credible if they limit that looking for victims to areas where they think they might find evidence. And at that point, there's no question but that the circumstances of the investigative activity they were engaged in led them to look for evidence behind the house. Nothing that they encountered initially led them to look for evidence upstairs. But if they were legitimately looking for another victim, there's no reason that they would not have gone upstairs. So in terms of consistency with their activity and behavior, in the early morning hours, we would contend that all of this is truly consistent with the version that Phil Van Adder offered to the Fiato brothers and to Agent Wax, that O.J. was our suspect from the beginning. It is also consistent with the modus operandi described by Detective Mark Furman in terms of the way he goes about police investigative activities. That a good policeman simply follows his instincts, finds the evidence, and then makes up the explanation or the probable cause or whatever justification may be needed later. And we believe that Your Honor should consider together the newly discovered evidence with respect to Detective Furman's credibility, along with this newly discovered evidence with respect to Detective Van Adder's credibility. Now, I know that Your Honor previously ruled that the newly discovered evidence regarding Detective Furman's credibility did not require a finding by the court that Detective Furman was credible because it really made no difference. His activity, the court found, was corroborated by the testimony of Detective Van Adder. But of course, Your Honor can't simply now reverse the process and say, well, we don't have to worry about Detective Van Adder's credibility because he was corroborated by Detective Furman. There's only two detectives who testified in the course of this motion to suppress, Detective Van Adder and Detective Furman. And we believe that in the face of this evidence that seriously undermines the credibility of both of these officers, the court is left with very little in terms of believable justification for the search activity that went on in the early morning hours. I don't believe Your Honor can simply dismiss the evidence undermining Detective Van Adder's credibility as BS. We're talking about two different incidents that occurred at two different times. We're talking about three different witnesses who heard statements to the effect that Mr. Simpson was a suspect from the beginning. In view of the importance attached to that revelation by Craig Fiato, assuming that he had very important and very damaging information to the prosecution in terms of the O.J. Simpson case, that he would be motivated out of revenge because he felt he had been poorly treated or poorly used by the DAs to make this revelation, suggests that it wasn't regarded as simply BS in the context in which he heard it. And of course, I think what Your Honor really has to ask yourself is whether the BS came from the witness stand or whether the BS came over a beer in a hotel room. I think all of the circumstances suggest that we may have heard more BS from the witness stand than we heard in that hotel room. And finally, this information can't be dismissed as a joke. Now, I was trying to think of what the joke would be for the punchline, O.J. was a suspect from the beginning. And I have to conclude that the only way you can explain that as a joke is that the joke was the Fourth Amendment. And I think we have to ask ourselves whether we can really be surprised if police officers treat the Fourth Amendment as a joke if we don't take the Fourth Amendment seriously in our courts. Believing that four detectives left the scene of this brutal murder unattended and all went to Mr. Simpson's residence at 5 o'clock in the morning simply to make a notification that at that time Mr. Simpson was not a suspect, requires us to really suspend our credibility, our credulity. And perhaps the only person in America who would still believe that that was the only purpose of their visit would be a judge ruling on a motion to suppress. If the police can expect when they come to court that the kind of testimony presented in this proceeding will be taken seriously, the game of police perjury will continue. And the only way we're going to put that game to a stop is to start to take the Fourth Amendment seriously, to demand that when police dispense with the Fourth Amendment requirement of a warrant and probable cause in order to engage in search activity, they have to come to a court and get justification, and they can't just make up the reasons afterwards to present a plausible explanation. If we want to demand that kind of police conformity with the Fourth Amendment, then we've got to enforce the Fourth Amendment.
People?
Your Honor, once again, I've sat here and listened to the defense bluster and engage in a lot of rhetoric when it comes to the search and seizure issue. They've attempted to make this report the same points repeatedly with this court to no avail. Now, we have here, of course, some it's not really newly discovered evidence. I don't even know if, frankly, I don't know how to characterize this, since it's evidence that happened, if it happened, after the testimony at the motion to suppress. So while it's newly discovered, it's also an after-the-fact evidence. At any rate, now what I heard Mr. Ullman saying is that they were renewing their motion to suppress the entry onto Rockingham, and that's all they're doing. So I'll address just that focus. And that, of course, was the hearing that was initially heard by the magistrate in municipal court, and which this court has had 2 occasions now to have to reconsider if that would be affected by anything newly discovered by the defense. The most recent being whether the Furman tapes would have affected that magistrate's ruling. The court did not have to reach that issue. Now, there's a couple of reminders I want to make. First of all is that the Bishop case, which is cited within my last response to their last motion to renew based on the Furman tapes, is that court is the one that construes the newly discovered evidence as applied to a motion to suppress made below. And it cautions the Superior Court, which acts as the reviewing court in this instance, that the court should look to new trial motions in determining the standard. And we know from, I cited Witkin to the court previously, and we know from the Bishop case itself that the appellate courts consider evidence, newly discovered impeachment evidence, as evidence which tends to impress weakly, because it doesn't go to the heart of what was testified to, but it's only calling one of the witnesses a liar in something that witness testified to indirectly, rather than directly by direct proof of something other than what the witness testified to. So we do start off from the basis that we have many times within this trial on a collateral matter, and that is whether indeed there is any
I don't know that I consider a statement that is in direct contravention to testimony as being collateral.
All right, and
on a
as I was saying
material
that, I was thinking I have a reason for saying that, Your Honor. It's a inconsistent statement of the witness who testified. So in that sense, well, it still is collateral. But the main reason I say that, Your Honor, and the point I want to make early on in talking to you about this motion, is that the state of the law now, then, and for a few years now, is that the subjective intentions of a police officer, whether it be to arrest someone, to detain someone, or to enter a residence in exigent circumstances, is not controlling anymore. That was pre-Proposition 8 law, and there's one case in particular I'd like to cite to the court because it's a 1995 case, People v. Hull, Hull, at 34 Calap 4th. I'm sorry, 34 Calap 4th, 1448. And in that particular case, which was 1995, as I mentioned, the defense argued in that case that the court had to determine whether the officer's entry into a residence was both objectively and subjectively reasonable before it could decide the search and seizure issue or whether the entry was appropriate under exigent circumstances. And the Court of Appeal directly held no. That was old law. That was pre-Prop 8 law. You know, we have Prop 8 and Lance W. Remember all those cases, which I know you've heard countless suppression motions with regard to. Subjective intent of an officer no longer controls, and it doesn't, frankly, even have any relevance in the instant situation because all of the circumstances known to the officers warranted what they did. And what I'm pointing out is the most obvious thing. I won't save it till last, but in addition to the newly discovered testimony of the Fiato brothers and Agent Wax yesterday, the court has heard from Commander Bushy, who said he ordered these detectives to go over to the house. So regardless of whether Detective Van Adder may have considered Simpson a suspect in his own mind, that's not why he went there. And even if that's why he went there, it does not matter, Your Honor, because the law says you look at the objective facts and what would be objectively reasonable for an officer to do, and not what was in any particular officer's state of mind. And that whole course makes that plain and clear in rejecting a defense argument to the contrary. And it upheld the exigent search in that case.
1448, page.
1448. It may still be in the advance sheets rather than a bound volume, but it's final. Somebody double-checked for me with the Court of Appeals, still published and final. The remitter is issued.
What division is that from?
It happened to be 3rd District, Your Honor. But, of course, any state court of appeal opinion is binding on any superior court.
Indeed it is.
As you're well aware, I know.
Yes.
I'd just like to throw in when it happens to be 2nd District, this one does not happen to be.
No, just a professional curiosity.
Mm-hmm. So, Your Honor, here we have a few things for the court to consider. We have whether, and the basic premise, remember, is for you to determine whether this evidence would have affected the ruling of the magistrate below. And I submit that when you look at this in conjunction with the state of the law, which is that the officer's subjective state of mind does not matter, and when you look at it, all of the newly discovered evidence, or the new evidence, I should say, including Commander Bushy's testimony that they were ordered to go there to make notification, it's clearly something of too little import to have caused the magistrate below to grant the suppression motion, and that's basically what had to have happened. And if you recall, as I argued the other day, the Bishop Court indicates that mere relevance is not the standard in terms of whether it would have affected the ruling of the magistrate below. It has to be more substantial evidence, something more substantial, and something akin to what the new evidence would be on a new trial motion that could warrant a court granting a new trial and would likely to lead to a court granting a new trial based on newly discovered evidence. And as I pointed out the other day, as Witkin and Epstein remind us, for a court to grant a new trial based on a new witness on newly discovered evidence, which goes only to credibility or impeachment, is virtually unheard of. It's just simply not done because it is considered collateral. And so to go back to that, in terms of talking about collateral evidence, this evidence is collateral in the sense that his subjective state of mind didn't matter. Now, Detective Van Adder ended up testifying extensively to that, but I submit, especially if you look at the correct standard that you have to apply in determining whether their entry onto Rockingham was proper, he could have been a suspect. There would have been nothing wrong with Detective Van Adder feeling that he was a suspect if he had. The point is he didn't, but if he had, it is the ex-husband the ex-wife of someone who was murdered. And, you know, that person, until you rule out people and can start to narrow it down, everyone is a suspect, so that anyone closely associated with that person is a suspect. So the point to all this is not that his state of mind is critical in terms of the motion to suppress, but only that the defense has tried to get the jury to disbelieve Detective Van Adder. And it's interesting in this regard that they are only now bringing a renewal of the motion to suppress. I don't know if they watched the news last night and decided maybe they better do it for the record or something, but it's amazing to me that that was not their first line of attack, as it was, I believe, with the Furman tapes. It's only today, as a virtual afterthought, after the jury has heard all this evidence and they've gotten in front of the jury, that they decide, wait a minute, maybe we ought to ask for a motion to suppress as well. So I think their lack of timeliness, well, certainly the court, if it were inclined, could deny it as untimely, but I know this court acts conscientiously and wants to look at it.
Well, no, what happened is during the course of the 1054.7 hearings where this information was first disclosed to the court by Mr. Hodgman and Mr. Yokelson, I discussed with Mr. Hodgman and Mr. Yokelson the likelihood that this renewed 1538.5 motion would be one of the obvious consequences of that disclosure if the witnesses did, in fact, after their interview, testify in the manner in which they did yesterday. And when the disclosure was actually made to counsel, and my recollection, Ms. Lewis, is that you were not present during our Chambers conference where these matters were actually turned over to the defense, that was one of the suggestions that there would be a renewed 1538.5. So this is not something that comes as a surprise to me that this is here.
Okay,
So I think we've all been on notice that this is coming.
Well, it's not a surprise because, and we expected it, and I even wrote a brief in anticipation of it, which I don't believe the court needs to address additional matter which hasn't been renewed. But the fact that we expected it, it doesn't mean we weren't, in fact, we were surprised the opposite. That just actually drives home my point, Your Honor. I don't know if the defense, I don't believe, because I haven't been told so, that the defense ever raised it before today as something that they wanted to do, even though we all expected it because we just had that good experience with the Furman-McKinney tapes. So we all knew, and certainly the defense knew, having just brought the motion on the McKinney-Furman tapes, that they had the right to do this. And that's why I'm surprised that they didn't do it sooner, or didn't give notice sooner, or didn't make an issue of it sooner. So I don't think this, let me put it this way. I believe the record supports the court denying it as untimely. However, I know you to be a conscientious judge who likes to not to use that as a ground. So that's why I'm going on to talk about these other things, but it certainly doesn't appear to be timely. Just because we expected it doesn't make it timely. I mean, a lot of counsel forego doing things as tactical matters, that are expected and that they end up not doing as tactical matters. And this could have been one of those situations, particularly where they may have felt that the gamble was worth it to see if they could have Your Honor have the jury hear it without risking the jury not hearing it by you're limiting it only to a motion to renew and the motion to suppress. In other words, so that they wouldn't have the evidence considered for two purposes. Maybe they were afraid you'd split the baby or something and not let them put it in front of the jury if we had it in a motion to suppress. So there are certainly tactical reasons supported by the record why they could have decided not to bring one. And here, now that they've had their cake and eaten it too, and in terms of the jury hearing all this stuff, they have nothing to lose at this point by now bringing up this motion at this last late hour after you've already ruled in their favor with regard to all those witnesses, both Fiato brothers and Agent Wax, who testified yesterday. So they have nothing to lose whatsoever now, but I submit their initial lack of notification was a tactical decision on their part not to bring it earlier when they should have timely brought it. In addition, there are additional cases besides the Hull case, Your Honor. That's simply the most recent and is certainly the most on point in terms of being an exigent circumstances case where the officers forced entry onto a home. Mr. Yeoman makes the repeated point about the officers' actions once they entered onto the premises. That also reminds me of something, if I recollect correctly, and I think I do because I reviewed this recently, Detective Van Adder's testimony was that once they had been at the premises for something like 45 minutes, they had contacted West Tech. They knew the defendant, West Tech had no knowledge of the defendant being out of town. They saw a light on, I forget if it was upstairs or downstairs, but some light in the interior of the residence. I think they saw a light on outside, and I can hear Mr. Cochran real loudly if you wouldn't mind just cutting it down a little bit. Thank you. So they saw a light on in the residence. I believe it was upstairs, but anyway, it was inside the residence. They rang at the bell. They couldn't rouse anyone. West Tech said they had no knowledge of him being out of town, and that's, I believe, when Detective Van Adder indicated he did become concerned for the lives and welfare of the defendant who was in there. So that flowed naturally. So they did have additional reason, besides Commander Bushy ordering them to notify him for the reasons Commander Bushy articulated eloquently in court. They did have good reason to go onto the premises and try to find him. And their actions once they entered the premises were consistent with trying to find Mr. Simpson. They went up to the front door and knocked on it, got no response. They went to the first guest house, the first guest room down there, and knocked on Cato's door. He didn't tell them Simpson wasn't home. He didn't know, or he didn't say anything at that point in time. I guess he knew because he'd helped him pack off, but he didn't. The state of the record is that he did not say anything at that point in time to these officers. So they went on to Arnell's room while Detective Furman appropriately stayed behind to see if there was anything suspicious about this man who looks like Cato looks in the defendant's guest house, considering the murders that had just transpired. Excuse me. He picked up his clothing. He asked, "Are these the shoes you wore last night?" Totally consistent with wondering if he might have been the murderer, to look and see if there's blood or dirt in the bottom of those shoes. And then, the rest is history in terms of Cato describing the thumps and him going to do that. But the other three detectives, all the three D3s, went ahead for their primary purpose, and their purpose, period, to find the defendant. And that's when Arnell initially said, "Isn't he home?" Something like that. And so she wasn't aware. It's also about that time, I think, that either Arnell said the maid was off this weekend, or it was after she let them inside the main house, that they looked and saw the maid's room, which was downstairs, where the bed was made, and it was clear the maid wasn't working that night, so they didn't have to worry about her safety and run upstairs for her. And then they got a hold of Kathy Randa. Kathy Randa told them the defendant had gone to Chicago, and they got a hold of him there. So everything they did was consistent with a search for Mr. Simpson. And for the defense to reiterate about 4 detectives going to the Rockingham for these purposes, Your Honor just heard Commander Bushy say it's not unusual at all in this situation. You have 2 kids at a police station that one of them may have to do something to take care of. You have a grieving family that they indicated it may be appropriate for a detective or officer to stay with until a clergy person arrives. There may be other witnesses to be interviewed. There's a lot of potential things that could happen. So to have 4 detectives go to the home when it's O.J. Simpson, and the police are being especially circumspect to do everything because they know they're going to be subject to higher scrutiny than perhaps they should be, and they have been indeed throughout this case. And I'm not saying higher than they should be, but higher than they normally are, certainly. They were subject to heightened scrutiny. And it went on and on and on, has gone on and on and on. Here we are again, right at the end of the evidence in the case, arguing the same stuff again with regard to their actions. But their actions were proper. Certainly, if only 2 detectives had gone and there had been a need for emergency help, they would have been highly criticized for not having additional detectives available to handle it. So all of the actions and conduct of these detectives when they arrived there and their reasons for arriving, all of them were perfectly circumspect. Detective Furman would have been negligent in his duties as a police officer not to investigate the noises that Cato described on the wall, and he did what was appropriate in that situation. The detectives in this case, acted appropriately throughout all of those circumstances and that timing. And if Detective Van Adder was tired and getting up in years when it came time to writing the affidavit, he may have made some errors, and the court has already found those. But I don't think the affidavit that he made when he was tired after being called up in the middle of the night, when the detective was called in the middle of the night, the affidavit he had to get out quickly for purposes of a search warrant that day, I don't think you ought to consider his credibility in that light. I think you ought to look at the testimony yesterday and the testimony of Detective Van Adder of the 8 days he was on the witness stand. The court had a lot of opportunity to observe him and listen to him and decide for yourself if you find it necessary to decide whether he was credible. And all of that was after the court had to rule on the search warrant affidavit. So certainly the search warrant affidavit is something, they're not re-raising that in terms of Fourth Amendment issues. So I don't think that's what the court should look to in terms of deciding that indeed this newly brought motion to suppress should be denied.
Four brief points, Your Honor. First, with respect to the timing of this motion, I don't think it can be seriously argued that this motion is not timely being made
Counsel,
within a week of the...
Don't waste any
Okay.
time on that.
Our concern was that the court not have to hear the testimony twice. It was obviously relevant for the jury to hear, and now we're asking that the same evidence be incorporated into the motion. Point 2 is the testimony that we have asked the court to now consider as newly discovered evidence is the testimony of Detective Van Adder, the Fiato brothers, and Special Agent Wax. I did not mention Commander Bushy, and the reason I did not mention him is specifically because his evidence is not newly discovered. Commander Bushy was available to the people at the time the motion was heard before the magistrate. There is no basis for the people to offer Commander Bushy now as newly discovered evidence that was not previously available to the court. But in any event, we would remind the court that there was no testimony by either Detective Van Adder or Detective Furman that they were responding to any order from Commander Bushy. In fact, Commander Bushy was never mentioned by either Detective Van Adder or Detective Furman in the course of their testimony on the motion to suppress. So we would contend that even though he is not newly discovered, Commander Bushy is, for any purpose of this motion, irrelevant. Third point, the issue presented here is not the subjective belief of the officer versus the objective belief of the officer. The issue here is the credibility of the officer. The question here is whether we should believe these officers in terms of the circumstances that they have outlined as giving rise to their reasonable belief that they needed to make an immediate entry and that their purpose in making that entry was to look for victims or to make a notification, as opposed to being engaged in a search, either for a suspect or for evidence of a crime. And when you boil it all down, what we have here on this motion to suppress are two police officers, Detective Van Adder and Detective Furman. And on the evidence now before the court, with the newly discovered evidence, must make a new finding with respect to their credibility. This court is no longer bound by the finding with respect to the credibility of these officers that was made by the magistrate. And with the evidence that is now before your honor, the evidence of the Furman tapes in terms of Detective Furman's approach to the investigation of criminal activity and his propensity to simply create a reasonable explanation after the events have taken place. The evidence of Detective Furman's perjury in the testimony in this trial. The evidence with respect to Detective Van Adder's misrepresentations in the affidavit that this court found justified a conclusion of a reckless disregard for the truth. And now the impeachment, the direct impeachment of Detective Van Adder by three witnesses who testify that he indicated O.J. Simpson was a suspect from the beginning. This court is simply left with a record of two liars, and two liars cannot corroborate each other.
Thank you, counsel. All right, we'll take our mid-afternoon recess at the moment. I'll read the whole case and come back and give you my ruling. Yes.
Just as a matter of calendaring and how we proceed after that, will the court consider taking Mr. Scheck's, the people's request for judicial notice when we come back?
I'd like to
as the next
resolve the Sims issue next.
Oh, yeah, that'll involve Mr. Scheck also. Sims, and then those two issues. That resolves him, so he can then be finished. And I guess I wanted to know, depending on what you rule on that, there'll be a question of whether the jury will be brought in tomorrow.
I'm sorry?
There's a question of whether the jury will be brought in tomorrow.
That is correct.
So we need to hear that.
Which is why I'd like to resolve that
Okay,
next.
let's resolve those two things. Or
Yes.
Those two. Thank you.
All right. The jury is not present. With regard to the renewal of the 1538.5, I think, there you are, Mr. Ullman is correct that the court's evaluation is that of the witnesses who have testified in support of the motion at the preliminary hearing, and therefore the testimony offered by the prosecution of Commander Bushy is not admissible at a renewed 1538.5. And so the record should reflect that in making these determinations, the court has not considered Commander Bushy's testimony, since the prosecution may only recall witnesses who testified in the original motion. Having said that, the court has evaluated the testimony of Agent Wax, Craig and Lawrence Fiato, and also evaluated the circumstances that circumstances and context that surround those discussions. And the court, in noting the context, that is drinking beer in a hotel room and standing around smoking on the smoking deck on the 18th floor, strike the court as being relatively informal circumstances. And the context leads the court to believe that the comments, if in fact made by Van Adder, and I believe they were, I don't find significant weight can be placed upon them. In evaluating what impact that has on the credibility of Detective Van Adder for these purposes, I find that it does not have significant or overriding impact that would cause this court to reevaluate the original finding. The conduct outside of the Rockingham residence, when viewed objectively, does not indicate a search for the defendant to arrest him or to otherwise invade his home. The officers stayed outside the residence for a considerable period of time. They attempted to get a response from the residents inside and were unable to do so. Rather than at that time breaking and entering, they sought assistance from the West Tech Alarm Company. The West Tech Alarm Company responded. The information that they gave to the officers raised the concerns even more. The indication being is that there was no information that the defendant was out of town or should have been out of town, and that there should have been a housekeeper on the premises at the time who should have been in a position to respond to the knocking and ringing by the police officers. The prosecution is correct that the standard cited in Hull by Justice Nicholson is the standard that is applied to cases subsequent to the imposition of Proposition 8, so the court's previous ruling stands. All right, let's move on to the Henry Lee notes and whether the defense should be allowed to recall Mr. Sims. Mr. Scheck, do you want to address that issue?
I'd rest on the arguments. I think that...
All right. I just wanted, if you could, a word of interpretation on Dr. Lee's notes then. What I have before me, and this is defense discovery pages 764 through 770, and on the
Tell me which date. Is this the February or the April note?
this is the April 2nd.
Right.
And am I correct in assuming that otolidine tests were done on the BSOC and that results, positive results, were noted inside on the inner surface on the BSOC?
That, it appears to me that in some areas that's true. There are a number of areas on that sock, yeah.
All right, Mr. Scheck, do you have any other explanation as to why the court should allow the recalling of Mr. Sims in light of it? It appears that the defense had possession of the sock at Mr. Taylor's facility in Altadena, which is, a local community here. That the previous complaint was that at the LAPD that Dr. Lee was not given a professional welcome and was not accorded appropriate equipment. But it appears that at Mr. Taylor's facility, Dr. Lee and Professor McDonald had free access to the sock, were able to test it, examine it microscopically, to take photographs, to do testing. And is there a reason why we should go beyond at this point?
No, I think I stated the reasons before. If the court wants to hear them again.
Well, in light of what I see here, can you tell
I
me?
don't think this makes any difference. I mean, assume, there were early notations by Mr. Sims as to what he saw in November. He was the first person that saw the socks in their pristine form. Then in July, he and Dr. DeForest make additional examinations in light of what the defense witnesses said about the ASOC. They then come up with information that corroborates the fact that there's a wet transfer from surface 1, surface 2 to surface 3 on the BSOC. Now, let's posit, and I don't think these notes are definitive of anything, but let's just posit that our experts missed it, and their experts found it. If it's exculpatory, it's exculpatory.
People? And forgive me for re-asking, Mr. Scheck, but I have a lot of other issues I've had to contemplate. So when I asked to revisit an issue, I'm not...
No, Your Honor, I was trying to be succinct.
Thank you. Ms. Clark.
I don't think I understand Mr. Scheck's argument, but first of all, the diagrams make it clear that Mr. Lee made the relevant observations back in April at Mark Taylor's laboratory. That's what the otolidine tests are all about. That's why you have the diagrams and the number of pages devoted to SOC B with, I think it lists positive, negative, showing an entire list of testing stains that he did. So they obviously knew about it back in April. Obviously, they chose, for reasons they're most aware of, perhaps they thought that the SOC A stain was more probative, and they could elicit better expert testimony about it. In calling, let me see if I can frame this tactically speaking, Your Honor, what they do in calling only Gary Sims is attempt to put the issue in front of, they have the testimony of Mr. McDonnell. Assume hypothetically, Your Honor, that Mr. McDonnell looked at SOC B and said, I'm not going to be able to give you your planting theory on this one. It just doesn't look right. There's only a couple of yarns where there's an indicated transfer. You can't say it's transferred from the surface 2. It could be transfer as a result of Mr. Simpson's bloody finger, and I just can't give you what you want on that. So what they do is they call Gary Sims to testify to the few yarns that seem to be, that give a positive result with the presumptive test, his observation of those couple of yarns, and leave it at that, hinging the inference on Mr. McDonnell's previous testimony. And that way, they get all the inferences they want and all the implications they want without ever having to be shown up for the fact that they cannot link it up with Mr. McDonnell's testimony. It will then be up to the people to set the record straight. Number one, that the surface 3 stain cannot, or can't call it a stain really, it's so tiny, but what they see on surface 3 cannot necessarily be attributed to transfer from surface 2. Number 2, that if there were planting, you'd see far more than a couple of yarns transferred. Number 3, that it could easily have been transferred by a bloody finger. Or number 4, that it could have been the result of phenolphthalein tests. Or number 5, from the way the socks were laying, the toe folded up on the ankle in one photograph, I think it showed.
But let me ask you this, Ms. Clark. One of the things that concern me is, well, let me tell you two things that concern me. One, actually three things.
Okay.
One, these notes from Dr. DeForest were turned over relatively recently, at least the ones that were held back for 1054.7 purposes, which I then ordered disclosed, which was within the last week or 10 days. Secondly, Gary Sims was the prosecution's witness who testified to the wet transfer stains on SOC A, and did so, I thought, in a very concise way.
I don't remember him testifying.
Thirdly, during the course of our discussions, when we had Mr. Sims back here, the defense did ask for permission to retake him as a defense witness to go into the areas that they wanted to go into at that time. I told them that I would likely allow that. Then you objected, or I think it was Mr. Darden actually who objected, and indicated, no, if they want to take him as their own witness, let them call him in their case. So I said, okay, with that representation, I hate to drag Mr. Sims back, but I did tell him I would allow Sims to be recalled. So I'm kind of in a situation where, because of the objection, we've got to drag him back.
Well, you know, Your Honor, I disagree. The one thing that we did not get to litigate...
And I might add that I think tactically they believe that Sims is a good, believable witness before this jury.
Oh, I don't... Fine.
And that
Tactically,
for him to say that there's evidence of wet transfer, that's tactically great for them.
Well, number one thing, I do not recall him ever testifying that there was evidence of wet transfer on sake. I remember him discussing the powder that he saw on surface 3, but I don't recall him saying it was a wet transfer.
All right, Mr. Scheck, excuse me just a second. Mr. Scheck, do you have Dr. DeForest's notes, the ones where it does discuss the wet transfer?
Yeah, I don't think Ms. Clark is disagreeing that Dr. DeForest's notes say
No.
wet transfer. I think what she's saying is that previously Mr. Sims had offered testimony which allows her to argue that the stain on sake is not a wet transfer, but is flaking from fibrils
Right.
that arose
Got it.
from the cutting.
Right.
That's precisely why you're in trouble on sock B, because he says something different.
Well, no, I've talked to Mr. Sims. We're not in trouble. Excuse me. But nevertheless, the problem that I have with the defense posture of saying we can recall him in our case in chief is the court did not give us an opportunity to be heard with respect to whether it was an appropriate thing to do. The court is aware, this is an unusual posture to be in, but the court is aware that at the time we presented Gary Sims, we were in our rebuttal case. The defense had rested their case, subject to Whitehurst only. They sought no provision for Gary Sims or any other witness. And the people specifically requested of the court that the conditional resting be not permitted to expand the defense case out into the outer realms of the universe just because they had not formally rested. Otherwise, we can go on forever. I mean, we can just keep calling people. So can the people.
Correct.
You know, this has got to end somewhere.
Let
But
me see counsel without the court order, please. All right, thank you, counsel. Is the matter submitted? All right, I will allow the reopening for Mr. Sims. I'll direct counsel to call Mr. Sims this evening or later this afternoon, re-interview him with regards to this one particular issue, and make a tactical determination whether or not you still want to present that. All right. Okay, exhibits. Mr. Douglas.
Yeah, was the next thing that judicial notice motion for Mr. Sheckman?
Okay,
That way I can go find
judicial
Mr. Sims.
notice.
Actually, Your Honor, I don't think I know we're not ready, and I've been told the defense is not ready on exhibits this afternoon.
Mr. Douglas, how many exhibits are there?
Your Honor, there are 130 or so of the people's exhibits that they have sought to introduce since we began our case on July the 10th. And then there's the question of those exhibits that the defense has offered since we last had that issue a few weeks ago.
So how many total do we have?
Approximately 160.
All right, Ms. Lewis, when are you going to be ready to do that?
Actually, I won't be arguing, so I'll defer to Ms. Clark as her best estimate as when we'll be ready to handle our exhibits.
I assume we're going to do this the same way, that we'll sit down informally, decide which ones we're going to fight about.
You're going to be doing jury instructions tomorrow, right?
I was hoping to do it today, but it looks like we're not going to make it.
During the course of jury instructions, we have people preparing on this right now, so, like, maybe after the
The problem is there's a lot of you and there's only one of me.
on the exhibits.
Exhibits and instructions.
I don't have a feeling for how long the jury instruction argument is going to be.
Well, you've got 42 special instructions offered, so
I think some are going to be more hard fought than others. It's going to be hard to gauge them. We can be prepared, we have to go through all of these exhibits. I think the ones that I have highlighted here are the ones that Mr. Dudley is objecting to.
That was 42 from the defense.
all right, well, I'll tell you what, let's hear the motion for judicial notice, and then we'll launch into see how far we get on the other matters.
All right. We don't have the defense objections to our exhibits, and I think that we have almost completed the defense exhibits the last go-round that we did, didn't we?
Just about.
How many remaining defense exhibits have we not litigated? In March?
Tell you what, let's do the judicial notice issue now, and then we'll take a break, and I'll take you and Mr. Douglas back in the chambers, and we'll schedule this. All right. I'm sorry? 13. Only 13.
We need the defense objections to ours. They only have 13. That's pretty easy to handle. We need to know what they object to in our exhibits before we can...
Okay, well, we can do this informally. All right, Mr. Scheck. I'm sorry, Ms. Lewis, you're the proponent of the request for judicial notice.
Mr. Goldberg is
Mr. Goldberg.
Good afternoon.
I knew I'd get it right sooner or later. Good afternoon.
We're asking for judicial notice, Your Honor, in relationship to several questions in 4 areas that were propounded to Dr. Lee. I don't know whether the court had an opportunity to read our request for judicial notice. It's actually fairly brief and succinct, and I hope states our position rather clearly, but I'd just like to emphasize the key points for Your Honor, because I know that you've been covering a lot, as the court has previously pointed out in the last few days. There are 4 areas that we're complaining of. The gravamen of all of them is that in each one of these instances, there were a series of questions that were asked Dr. Lee that had the clear and unmistakable effect of conveying to the jury the overall impression that the prosecution somehow unilaterally determines when and under what circumstances the defense can have access to evidence, as opposed to the court making those kinds of determinations, or at least having a substantial role in making those determinations. And also, these questions were couched in language, and the testimony was couched in language which elicited testimony to the effect that that Dr. Lee was prohibited or denied access or wasn't allowed access to the evidence until certain dates. The first such instance, Your Honor, is in relationship to the inspection of the socks, and the court will recall that there was fairly extensive testimony by Dr. Lee about how he felt he was treated at LAPD and the extent of the time that he had to look at the socks only being 20 minutes. I think he testified, even though in actuality I think he had more, but he implied that it was only 20 minutes. In reality, the socks had returned from the Department of Justice on November the 22nd of 1994, and there was no application to this court to look at the socks between November the 22nd and February the 16th. And clearly the defense could have done it before February the 16th. I think it was the defense that decided to do this at the very last moment before it was sent to the Department of Justice. So this is a wrongful impression that has been created in front of the jury. The second item was that the defense asked a number of questions about the Bronco that were couched in terms of acting Dr. Lee. When were you first allowed to visit the Bronco, or when were you first permitted to look at the Bronco, and words of that kind. They used that sort of language on a number of occasions. On some of the occasions, we objected and objections were sustained, but this was one of those instances where we felt that the answers to the questions still left the impression that somehow it was the people that were not permitting Mr. Lee to look at the Bronco. And again, this is an area where the defense never made any application for this court or complained to this court about Dr. Lee's access to the Bronco. The third area was in relationship to the inspection of the Bundy crime scene, where Dr. Lee said that he was ordered by someone, I don't know who, we weren't able to confirm this one way or the other, that he could only be at the crime scene for 20 minutes. However, he never made any application to this court, nor was any complaint ever lodged with this court. Actually, what happened is I believe that prior to the time I came on the case, there was an informal agreement, or maybe a formal agreement between the parties, that the people would have reasonable access to the Rockingham location for certain inspections, and that the defense would also have reasonable access to Bundy. But the unmistakable impression was left in front of this jury that the only access the defense had was this 20 minutes, and they were ordered that they could only be there for 20 minutes, and they were prohibited from doing the kind of testing that Dr. Lee would have liked to have done. And then the fourth item that was testified to by Dr. Lee is he stated that Mr. Shapiro had told him that the only photographs that they had received from the Los Angeles Police Department in terms of crime scene photographs were second or third generation photographs. As the court knows, both from your experience as a prosecutor and also as a judge, we always provide in discovery original photographs from negatives, which was done in this case and is done in all cases. In fact, I don't even know if we have the capacity to routinely provide anything other than that in terms of photo shooting photographs and then providing second or third generation copies. So the jury has been left with the impression that we gave the defense less than satisfactory evidence. That is clearly not true, and we believe that misimpression should be rectified. Therefore, we are asking that the court take judicial notice, as the people have requested in our application for judicial notice, as to these four items. What the court is being asked to do is to take judicial notice of the law of the state of California in terms of discovery obligations, and inform the jury that the people do not get to unilaterally make these kinds of decisions, that applications can be made in front of the court. That is mandatory under the Code of Evidence. And then we are also asking the court to take judicial notice of the court's own files, that certain applications or orders were not sought for these four specific items of evidence, and that is permissive that the court can take judicial notice of that under the California Rules of Evidence. So we would respectfully request that the court take judicial notice of these items in order to correct these misimpressions in front of the jury.
Thank you, counsel.
Your Honor, this reminds me of that scene in one of my favorite legal movies. I think it's My Cousin Vinny, where the defense lawyer gets up and says, everything that man just said. And I'll just, after the Fiato brothers, it's incorrect, both on the facts and the law. I actually had to go up and look at all the page references here that they filed. And I'm concerned about Mr. Goldberg's page references. He says the defense also implied the defense was wrongly denied access to inspect the Bronco. Now, the questions were, at the bottom of page 43022, Dr. Lee, before I move on to the next series of boards, I'd like to ask you briefly some questions about the Bronco. Did you have an opportunity to personally inspect, examine, and look at the Bronco? No. Could you do a reconstruction of the Bronco? I cannot do a reconstruction because I do not have a direct examination observation of the original condition. It was perfectly clear that he was going to give very limited testimony just from photographs, and he was explaining when you can do a reconstruction and when you can't, and if you don't look at it, you can't do it. He was only explaining the limitations of his testimony. Now, with respect to the examination of the socks on February 16th, Mr. Goldberg is again in error with respect to the motions that went back and forth on access to this evidence. And I don't believe that he was yet active in this case and doesn't have the same recollection of this that I think you and I do. And that was that there was extensive and extraordinary litigation about access to the biological evidence in this case, and when we could do testing and when we could do anything more than simply examining or looking at it, and even then under what conditions and circumstances. And the fact of the matter was that the socks were under examination, and prosecution took the position that they weren't finished testing until Mr. Sims's report was out, and that was in January. Now, unbeknownst to us, if they had actually sent the socks back at some point to the LAPD, unbeknownst to us, it wasn't clear to us that they had finished testing because they were sending them back and moving them back and forth, and they hadn't finished their DNA testing. And as the court distinctly recalls, when we finally, after weeks of negotiation, had reached a plan to send physical evidence to Albany, and Dr. Lee's testimony was completely accurate as to what the terms and conditions of that order was, in terms of being able to look at it and examine it. When we had done that, this whole issue of EDTA testing arose. That is, that the prosecution said, we want to do EDTA testing on certain designated items of evidence, in particular the socks. And of course, the socks were the items of evidence that we wanted an opportunity to examine firsthand and do testing on the most. And in your chambers, with Mr. Yokelson and Mr. Hodgman present, I turned to the court and said, well, if we get Dr. Lee down here from that conference in Seattle, can we have an opportunity to look at the socks? And what followed is 100% accurate in terms of Dr. Lee's testimony as to when the terms were that a courier was flying out.
They were about to be packaged up and sent off.
And sent out, and we sat there waiting, and you can bring Mr. Hodgman and Mr. Yokelson down there, and they'll tell you that every syllable that Dr. Lee uttered about what those facts and circumstances were true. And as far as what went on in the evidence processing room, I was a witness, and I know what I saw. Now, Dr. Lee testified to what happened there, and those are the circumstances that they put together in terms of his inspection of the evidence. Those are the boards that Mr. Harmon chose to put in. That was the testimony they chose to elicit from Mr. Yamauchi. Dr. Lee expressed himself clearly about what he thought of it. They got to live with it. They did it. As far as access to the crime scene is concerned, Mr. Goldberg indicates that he is in no position to give a factual refutation as to what the terms and conditions were of Dr. Lee's inspection of the Bundy crime scene. The record is very clear that Mr. Shapiro had sent letters to the police department and had made requests of the prosecution and the people at the crime lab for Dr. Lee and Dr. Baden to have access to the evidence as they were testing it. Ms. Kessler made very clear that that would not be permitted. That was not their policy. They were going to get to deal with it when they wanted to, how they wanted to, and we've had a lot of litigation about access to the evidence. And those were the terms and conditions. He wanted to get the crime scene as soon as possible. Their argument in closing is going to be that some of the observations he made there that day should be ignored by the jury because some other unknown people might have left imprints on the walkway. And we have to live with that, but our access to that crime scene was limited, and they have to live with what they did with it. Those are the facts. He has said nothing here that in any way contradicts the facts as Dr. Lee stated them. Then there was the whole issue of the photographs. I actually looked every one of these quotes up. And at 42895, all Dr. Lee has said, these are 3 pictures given by Attorney Shapiro. At 43241 to 43242, it's Mr. Goldberg, as I understand, asks if the picture on our board is a photo of a photo. And it was made clear that we had small original photos given to them, and then we blew them up as photos of a photo. That's all that's there. He asked that question. Then there is testimony on 43276 to 43277, where Mr. Goldberg shows the new and much better pictures that Agent Bodziak testified were prepared in August for purposes of confronting Dr. Lee in the witness stand. And Dr. Lee said, don't have picture as good as this. And then he indicated that even this picture, which was an overall picture of the walkway, was taken at an angle, and it was selective in that it was focused on the Bruno Magli prints and not in any other prints. And that's what he said. Then he was asked something to the effect of, well, didn't you ask for better quality prints? And he said, I asked Mr. Shapiro. He says that's all he had. Now, that raises the one issue which I think, frankly, is the genesis for this whole motion, which, as I'll get onto in a second, has no basis in law whatsoever. But I'm just concerned even about the facts here. And that is, there is a significant motion pending before this court with respect to the contact sheets, because I'm sure the court's recollection of this is pretty clear. And that is, we were asking for these contact sheets from day one. And they're going to have to listen in closing argument to the testimony of Mr. Rokar and what we were finally able to do when we got those contact sheets. Now, the record is indeed somewhat ambiguous. Mr. Hodgman can't recall whether or not we asked him for negatives. A court's recollection may govern on this, because I think some of these requests were actually made in your presence. It's Mr. Neufeld's recollection and my recollection. We did ask for negatives as well as contact sheets, but the point was they were in the exclusive control of the prosecution, and nobody disputes that we asked for contact sheets all the way through and didn't get them. And the contact sheets reveal an extraordinarily important fact about when that picture was taken of Mark Furman pointing to the glove. Very important fact in this case.
I'm sorry, we seem to be on to a different motion. We're all
No.
kind of shaking our heads here.
No, the point is that that motion is pending, and I'm saying as directly as I can, I think this motion is frivolous, and it's done because the court has put that under submission, is going to give that contact sheet motion serious thought, and factually, none of these things even state what they say. He never talked about wrongful denial. He just stated the facts as they were. The citations they make here don't support their position. Now, as for their legal position is bereft of one case citation. And that's for very good reason, because it is a complete misunderstanding of what one can do with respect to judicial notice. They are not asking for judicial notice of a statute or some public record or fact or anything that's laid out in 451. What they're actually asking for is that judicial notice be taken that if the defense filed a motion, or that if the defense, they want the fact that if the defense filed a motion for certain kinds of relief, then the court would have granted it. That's essentially what they're asking for in each of their requests. And it's inappropriate unless, it's inappropriate, period. And what it would really require is for the court to take judicial notice and summarize every single discovery request that was first given to the prosecution and rejected, and all the different motions that went into the litigation of access to the evidence in this case, which was fiercely litigated, including the court's decision that they could continue testing all the way through the case and withhold access to certain evidence. I've tried to look back at that file, and it's numbing. And it seems to me wholly inappropriate for this kind of judicial notice to be taken for which there is no citation whatsoever, that one can take judicial notice about court orders that were not requested, not note the ones that are relevant on point that did make requests, including informal requests to them as we're directed to do by the discovery sections. And it is totally not called for in light of the testimony that they cite here. So this application is wholly without merit on the facts and the law, and I submit to the court is really just a make-weight because they're worried about something else that the court still has under submission.
Thank you, Your Honor. Well, if that's the first time I think I've heard my cousin Vinny cited as legal authority in a court of law, what counsel perhaps doesn't know is I believe that that citation was overruled in the more recent movie of A Few Good Men. Your Honor, what we have is a situation here where counsel, through his clever phraseology and asking of questions, I don't think it's Dr. Lee's fault, creates certain impressions in front of a jury which are obvious to anyone that is listening to what is going on, obvious to this jury, which are untrue. And the issue is, does the prosecution get an opportunity to show that it's untrue? Yes, we can. And we can do that by offering evidence. And we could have offered evidence. Or we can do that in other ways that are permissible under the California Evidence Code. That is judicial notice. And when the court is either required to take judicial notice or may take judicial notice, that is an appropriate avenue to take to counter evidence that was offered and impressions that were created in front of this jury. I've already tried to state the factual basis for the record and perhaps would invite the court to look at this again, because it's not just a question of reading the literal language and the very careful phraseology that Mr. Scheck used, but a question of the court evaluating the overall impression that it created and whether it wrongfully created an impression that should be remedied and that should be set straight, that the people are entitled to set straight. Just very briefly, Your Honor, to give the court an idea of this overall statement that I'm making, that in general misleading information was put before the jury. On 42-900, Mr. Scheck asks, all right, now Dr. Lee, you mentioned before that arrangements were made so that the defense experts for the first time could actually examine items of evidence in this case at Albany Medical Center on February the 17th and 18th and 19th, correct? It's not really a complete sentence or thought, but what is clearly stated here is that the first time that they could actually examine items of evidence was on February the 17th, 18th, and 19th, that they didn't have any ability and weren't allowed to examine evidence before then. Similarly, on the very next page, 42-901, Mr. Scheck asks, were you able to, you or other defense experts to your knowledge, were you given an opportunity to actually examine physical evidence by touching it, microscopic examination, prior to the shipment of that evidence to Albany on February the 17th, 1995? And he said, yes. So again, it's making it sound like we did not give them the opportunity. Well, they didn't ask. They didn't make an order, an application for this court. When the socks had been returned on November 22nd, I believe Mr. Harmon sent a letter to say that these socks are back. Between November the 22nd and February the 17th, they could have asked to see the socks, and they didn't. But they have been led to believe, the jurors, that we did not allow them to, unilaterally said, no, you can't see these. The court didn't have anything to do with it. We just said, you can't see them, and they didn't get a chance to see them before February the 17th. It's a misimpression. On 43-030, in relationship to the Bronco, Mr. Scheck asked the following question on line 7. Couldn't get to see the Bronco itself Answer, no. Then on line 15 by Mr. Scheck, did not see the Bronco itself? No, I did not. Well, what does couldn't get to see the Bronco mean? On 43-022, he's asked the question by Mr. Scheck. Dr. Lee, before I move on to the next series of boards, I'd like to ask you briefly some questions about the Bronco. Did you have an opportunity to personally examine and look at the Bronco? Answer, no. So clearly, again, the unmistakable impression is being conveyed to the jury that somehow we did not give him the opportunity and he was denied access to the Bronco. Sorry. Mr. Cochran, are you finished? Yeah, I know, but it's a privileged conversation with your client, and I can hear what you're saying. Okay, thank you. And then in relationship to the photos on 43-276, he's asked the following series of questions by me. Doctor, did you ever ask the defense to provide you with higher quality pictures? Answer, I get the information, that's all the picture we get. It's total out of sequence, mixed up like a deck of cards. I spend a lot of time trying to make some sense out. Question, but when you got it from Mr. Shapiro, did you say, please send me some examination quality photos? Answer, I did ask it. He said, that's all he get. He took it back right away. I don't have the photograph. Now, Mr. Scheck, when he read this exact quote, you said that Mr. Shapiro said, that's all he has. He didn't say that's all he has. He said, that's all he get. Well, who did he get it from? The people. So again, what is clearly being stated is that all we gave him were photographs that were not examination quality. Look, I don't know why the defense does this. I don't know why they create misimpressions that are very easy to rectify, that are very easy to set straight either through evidence or through the provisions that are allowed by the California Evidence Code, and then complain when we try to do it. But Mr. Scheck did this. The questions are obviously very, very carefully worded and carefully phrased. But I think now we should have the opportunity to set the record straight. And under California law, judicial notice is an appropriate way of doing it. We are simply asking the court to take judicial notice of what the law is. It's a correct statement of law, that the court can decide when access can be granted and denied to evidence. And we are asking the court to take judicial notice of its own files, that such applications were not made. And we would ask the court to do so.
All right. Thank you, counsel. All right. Under ordinary circumstances, a request for a court to take judicial notice of certain facts, statutes, one of the basic requirements is that either there be no reasonable dispute as to the fact or circumstance that the court is asked to take notice of, or that the facts are easily susceptible of determination. These discovery issues were hotly contested throughout this case. There remains controversy today. There's nothing that we agree upon here between the sides. These are matters that could have or should have been resolved during the course of the examination of the witnesses in question. The request for judicial notice is denied. All right, scheduling of exhibits.
May I mention there's apparently an additional litigation that needs to happen. The court recalls the Gretchen Stockdale issue where we served her with a subpoena. She said, I gave them to the defense. We tried to get them from another source, and I believe the court was carbon copied on a declaration indicating the original source erased them in their normal course of business. And apparently, thereafter we asked the defense for them, and the note I have indicates that the defense destroyed it.
Well, let me ask you this. Do we anticipate litigating this? Because the indication I got from Ms. Clark is that both sides, subject to a final decision as to Mr. Sims, were going to rest, so there's no point to going into Gretchen Stockdale unless somebody's going to call her as a witness.
Well, this note has just been sent down from Ms. Clark.
That was my understanding, and further, Mr. Shapiro.
All right, well, may I just indicate it's still on the plate since they're going to call Gary Sims, the court's allowing it. We haven't yet decided not to litigate this. That's a note I just got from Ms. Clark, so apparently she wants to litigate it.
the problem is, and I don't want to get the hours late, but there'd have to be a reason. She just can't walk in and call Richard Stockdale. There has to be a reason to rebut something. And so that's what the law requires, and so they don't have that. They've said they've rested. The Gary Sims issue is something that came up before, but I'll ask you to take it up tomorrow when Shapiro's here, Your Honor, if we're going to deal with it at all.
Yeah, Mr. Shapiro was the one who was handling that aspect of it. Okay, what we have left then is the motion for an instruction regarding the contact sheets, the instructions in general, and exhibits.
I think Mr. Hodgman is most familiar with the contact sheet issue. Is that something that has yet to be
No,
argued?
that's under submission at this point. But that was a request for an instruction, so that's part of our instruction discussion. Who is going to handle the instruction discussions?
The instruction
For the jury instructions for the case?
Yes.
I believe we anticipated handling that tomorrow, because I may be mistaken, but I think Mr. Kalberg's going to handle that for our side, and he teaches, I think.
Okay. All right, are there any of the exhibit matters we can resolve this afternoon?
Your Honor, Court, please, I
Mr. Douglas, good
have the
afternoon.
majority, although Mr. Scheck and Mr. Neufeld have not yet given me their list. But we can begin perhaps with my identifying those exhibits to which there are objections and start the process in that manner.
All right, why don't we do this then? At this point, I would suggest then that,
Ms. Clark designated me in her absence if you wanted to do it informally in chambers.
yeah, I was about to say, why don't we just take a recess and formally go over we'll have Mrs. Robertson gather up the exhibits that have been introduced after this certain date. We'll just take them one at a time, and then we'll litigate. After we pare it down to the ones we have to fight over, then we'll take care of those.
There's an additional motion pending that Mr.
Your Honor, just the Henry Lee notes discovery violation motion. The court had ruled that there was a discovery violation in the late disclosure of certain notes related to Dr. Lee, but the court had not imposed any sanction. Asked the people to file a statement of what the prejudice was, which we did on September the 11th of '95. I don't know whether the court had the opportunity to read that.
I have
that
to-
does need to be.
Something that had slipped my mind for a while lately.
I know Mr. Goldberg expended considerable time and effort in detailing the prejudice that we suffered for the court's instruction, so.
All right, we'll take that up during the course of our instructions then.
One
All
more
right.
beside, Your Honor, that I think. One thing, Your Honor, that I was going to say, I was just talking to Mr. Scheck about it, so some of us may take our leave, but if in the event, how long will the court expect to be here? In the event that Mr. Scheck speaks with Gary Sims and there's some resolution one way or the other, we'd like to let you know this afternoon. It might have
I will
something to
be
do.
in the courthouse at least until 5:30.
All right.
And as you know, Mrs. Robertson can always get in touch with me.
All right. We may try to let you know something by that
Yeah, I
time.
would appreciate
I think that's
that.
appropriate, Your Honor.
All right, then what we'll do is we'll stand in, let me ask you this. Ms. Lewis, do you know when Mr. Kelberg would be available?
In
Sorry.
the,
How early tomorrow morning he would be available? Dean
Well-
Ullman, are you available as early as 8?
Mr. Kelberg gets up beyond my wildest dreams and ungodly hours of the morning, as is his normal schedule. I do need to make a phone call, Mr.
Yeah.
Hodgman, make
Mr.
sure that
Manning.
that was the designated person.
I don't think it's Kelberg. When he left this time, he said he wasn't coming back anymore.
I think he meant today.
He's promised that before, but he said that.
Mr. Ullman, are you available at 8?
I'm available if the court's convenience.
All right. Why don't you check and see if Mr. Kelberg is available? We'll start our informal jury instruction conference then at 8 tomorrow morning. I'd like to get this done tomorrow because I'd like to instruct Friday. All right. We'll take a recess. I'll have Mrs. Robertson summon up the items, and then we'll have an informal conference on the exhibits. Anything else? Always afraid to ask